very close and dear to my heart, which is the questions around the BBNJ agreement. So we are looking at beyond the text addressing the implementation challenges of biodiversity beyond areas of national jurisdiction agreements in Africa. The number of speakers that we are expecting today, we have Professor Maria Magdalena. Sadly, Dr. Kwame Mfojo, who's on the program, is unable to join us today. We have Mrs. Kalila Hartman, the Deputy Director, Ministry of Foreign Affairs. We have Ms. Peace Bekokove, who's joining as well now, Sebastian Camillo, and then Harun Rashid as well. A number of the presentations would be virtual. Some of the speakers are not able to be here with us in person. But it's an interesting conversation that I hope that we can all be introduced to. I want to emphasize particularly as we're going to talk about this agreement around some of the important discussions that led into this agreement, which is the newest baby, I guess, within the law of the sea space. Now, the idea in putting together the BBNJ was that it's one of the things that have been talked about for so long within the law of the sea space as the fourth implementing agreement of UNCLOS. And we have an agreement which at the pillar of it, you can see there are a number of pillars, which are about 3 or 4 of them. The first one is how do we deal with marine genetic resources, crucially the questions around fair and equitable sharing of benefits, including from digital sequence information. There are concerns, of course, for Africa, and I know we're going to be talking about some of these things about technological asymmetries that have historically excluded us from marine bioprospecting, the provisions on benefit sharing, technology transfer, capacity building, then which exist under the agreement for us then are not abstract ideas, but also allow us to have a real play into discussions around the emerging blue economy. The second key innovation under the agreement is also a pillar of the agreement is the area-based management tools, particularly the marine protected areas, which is seen as a way to protect the areas beyond national jurisdiction. And then a third pillar of the agreement is environmental impact assessments for activities in areas beyond national jurisdiction. And of course, finally, a key part of the agreement is capacity building and technology transfer. I'm very pleased to have persons who have been very involved on both in negotiating, but also in supporting and following closely the processes that led to the convention. This morning, our keynote speaker is going to be Professor Maria Magdalena Rojas Fernandez das Deves. I'm trying to mention all of your names today, Maria. Maria is an associate professor at the Faculty of Law and researcher at the Norwegian Center for Law of the Sea at the Arctic University of Norway in Tromsø. She's currently leading 2 research programs at the center. One, with the overarching project of developing good ocean governance of the Arctic in times of unpredictable and rapid changes. And the other on the limits and possibilities of sovereignty as the organizing logic and central principle underpinning the law of the sea and ocean governance. She also participates in the reference group work for the International Seabed Authority, created by the Norwegian Ministry of Foreign Affairs. Now, at the university, she is academic director of the LLM program and teaches in this program, as well as in the joint Nordic Master Program in Environmental Law. She teaches energy and climate change law, international law, EU trade law as well. She's been visiting and guest associate professor at Kobe University in Japan, also the Portuguese Institute for the Law of the Sea, UN Doualos Nippon Foundation Fellowship, and a close partner of the University of Ghana's own master's programs in Law of the Sea here. Of course, she holds an LLM from Tromsø and a PhD in energy law from Tromsø as well. We're very excited to have Maria lead the conversation today. She's going to be presenting beyond the text, addressing implementation challenges of the BBNJ agreement in Africa. And I'm very excited to hear her speak today. Please, a round of applause to welcome her.
Good morning, everyone. Thank you, Oliver, for your kind introduction. Dear colleagues and fellow ocean enthusiasts, it is a real pleasure for me to be amongst you today to discuss, as Oliver already indicated, an important topic of the BBNJ agreement. But before I do so, please let me convey to you the warm regards of the Dean of our Faculty of Law, Professor Tore Henriksen, and of the Director of the Norwegian Center for the Law of the Sea, Professor Vito De Lucia. Both of them are very pleased with the collaboration between our two institutions and wish to see the Center for Ocean Governance in Ghana grow and keep contributing to training future generations of law of the sea experts, and also to assist more and more the Ghanesian authorities in these areas of their expertise. So we are very much looking forward to this continued friendship between us. Now, with respect with today's presentation, and I think just as the lawyer that I am, I think I need to start with a disclaimer because I was asked to talk about the challenges with implementing the BBNJ agreement in Africa and how to address these challenges. But not being from Africa myself, and not having experienced firsthand the realities and the challenges that African states and their peoples are faced with, my presentation is based on my preconceptions, based on discussions with colleagues or topics that come up during BBNJ negotiations and so forth. Moving forward in my presentation also, considering that I have a number of distinguished colleagues in the panel that will address the same topics, rather than providing a very detailed presentation, I will rather provide a contextualizing overview of the issue to get the ball rolling, so to speak. Now, on the 3rd of March of 2023, Ambassador Rene Lee gladly announced, after what was some maybe tense and very long 36 hours of final negotiations, that the ship had reached the shore. The BBNJ agreement, which was then adopted by consensus by members of the United Nations in June 2023, finally addressed regulatory, governance, and institutional gaps or shortcomings in the existing international legal framework concerning the management, conservation, and sustainable use of marine biological diversity beyond national jurisdiction. Now, as Oliver already hinted, but I will just refresh this, the agreement does establish access and benefit regime for monetary and non-monetary benefits derived from marine genetic resources. It lays out a process for state parties to establish area-based management tools in marine protected areas. It lays out clear rules and thresholds for conducting environmental impact assessments, and provides a strong framework for capacity building, technology transfer, and technical assistance. But this ship now embarks on a new journey, because we are now at the phase of preparing for the ratification and implementation and entry into force of this agreement. And the Preparatory Commission for the entry into force of the BBNJ agreement has been holding sessions dedicated to clarifying a number of aspects that were left somewhat open-ended in the text of the agreement. And in particular, and I think we might hear this further on from my colleagues, the governance structures, rules of procedures, working modalities of the different bodies, for example, how the clearinghouse mechanism is going to operate, also issues concerning the financial rules, resources, and the financial mechanism, amongst other aspects. And in this fora, African states must continue really to advocate for their needs and their priorities in this context of PrepCom. Now, in addition to this, states must also start taking steps domestically and regionally for the ratification and implementation of the agreement. At the moment, we are only 5 ratifications short for the BBNJ agreement to enter into force, and it's somewhat expected that this may happen before the 3rd session of the PrepCom takes place in March, April of next year. Let's hope so, but what we really need is for the more universal reach of the agreement is to go well beyond the 60 ratifications required for it to enter into force. And as you can see from this map, a number of African states has already signed the agreement, but not many have actually ratified it just yet. And this leads me actually to my initial question before actually looking more closely at other implementation challenges. And this question is really, why should African states ratify the agreement? And actually thinking a little bit more about this, I think I could also add here, should they rush to ratify the agreement? And when I ask this, because after all, African states have perhaps greater concerns or more pressing concerns in marine areas within their national jurisdiction, not to mention in other policy areas. They have little to no activity in the area or high seas. They have no direct activities concerning marine genetic resources of significance. And they have not been the main contributors to the dire state of the ocean in these areas. On the other hand, when I reflect on this, African states have played a key role in the negotiations of the BBNJ agreement, in particularly championing and safeguarding of the principle of common heritage of humankind, as well as the regimes concerning the benefit sharing and capacity building and technology transfer. So essentially, it is something that we can think of, but typically what African states, like any other state intending to ratify an agreement, normally has to endeavor in, is to conduct a cost-benefit analysis and risk analysis, as well as a regulatory impact assessment. And in this slide, I've just present a non-exhaustive list of considerations to be weighed in this type of exercise. And typically one would consider, on the one hand, the diverse costs and risks of ratifying the agreement. Costs that the state will incur with the need to design or amend or even improve or implement existing or new legislation, administrative and policy measures. Costs with developing or improving institutional or interinstitutional coordination mechanisms, as well as cooperation within regional and sub-regional fora. Then costs for the population and relevant stakeholders resulting from the implementation of the agreement. Opportunity costs related or caused by potentially prioritizing the implementation of the BBNJ agreement ahead of other policy areas. Costs related with the participation in the BBNJ itself, in the conference of parties and in the different meetings of the bodies established under the BBNJ agreement. And also, very importantly, the consequences in terms of responsibility or risk of responsibility for failure to comply with their obligations under the BBNJ agreement. And here I note, if you read the BBNJ agreement, the expression, the parties shall ... appears around 86 times in relation to different types of obligations with different degrees of binding force. So this is an exercise that it's important to consider. On the other hand, and especially if we think also on a more long-term basis, ratifying the agreement can indeed help African states contribute towards ensuring the protection and preservation of the marine biodiversity and ecosystem services, importantly, for example, food security, not just for the present generations, but also for future generations, and another element of intergenerational equity. And African states will also be able to reap the benefits from the capacity building, marine scientific research, cooperation, and technology transfer enabled by the agreement, as well as reap the monetary and non-monetary benefits from marine genetic resources activities. Another positive aspect is that with the need to develop and review existing legislation in order to implement the agreement, this also needs to more updated and improved legislation that will also provide competence in respect to different topics such as environmental impact assessment, area-based management tools, marine genetic activities, and legislation and competence that will be relevant not just in the context of marine issues, but this also tends to trickle down to other types of legislation, including land-based activities. Because when we are designing, for example, proper regulation on environmental impact assessment, it doesn't have to be exclusive to marine activities. You can also take the advantage to think about this in the context of other activities. Another aspect that we can highlight is participation in the context of the BBNJ agreement does not need to be as costly, nor its implementation as initially thought, because African states can have access to different sources of funding in this particular area. And finally, and this is quite an important point, it is only by ratifying the agreement that African states can have a voice, a seat at the table in the decision-making processes concerning the BBNJ. And also it's a way for them to further strengthening their influence in marine, environmental and resource matters. Now, as far as I am aware, the African Union is not only very much supports the BBNJ agreement, but has also been working quite actively to support its member states in order to prepare for the ratification and implementation. The next issue then to look into is what are the key challenges that African states face in implementing the BBNJ agreement. And here noting that naturally these challenges, even though they might be similar across the African states, they will vary in their degree from country to country. And when I think about implementation in this context, I also go for a very wide, broad definition of implementation. And again, I will not go into too many details because I don't want to step on the toes of my colleagues after me. But so just to summarize, key challenges will be, well, first, a potential lack of full understanding of the rights, but also particularly of the obligations enshrined in the BBNJ agreement and their full ramifications. Gaps and shortcomings in the existing legislation, including the fact that a lot of legislation is outdated or inadequate to implement the BBNJ agreement, is also an aspect. The fragmentation, mandate overlaps, other shortcomings in institutional settings necessary to deliver the BBNJ obligations, or even poor coordination amongst different institutions or governmental agencies is another aspect. Then there are significant gaps in knowledge concerning the high seas, the area, their ecosystems, which in turn, these gaps in knowledge, preclude informed delineation of policies, informed decision making, or even effective participation in conducting environmental impact assessments, establishing marine protected areas, area-based management tools, and so forth. Now, there is also a lack of resources to conduct scientific research and develop new technologies. As you know, research vessels and other equipment tend to be very expensive, and also there are not enough currently qualified scientists, engineers, and so forth in these particular fields. Now, there is also a lack of sufficient personnel with training, with proper knowledge across different institutional and decision-making levels. A lack of means also, both human and in terms of equipment, to proper monitor activities in areas beyond national jurisdiction and to ensure compliance with the law. Noting here perhaps that across African states, naval vessels or Coast Guard vessels may be in limited number, but also keeping in mind that technologies that are typically used for monitoring, such as satellite tracking, remote sensing, etc., are also very costly in themselves. And they are typically not owned by African states, but rather by developing companies, companies from developing countries. Now, a big one also is the lack of funds, which again is transversal to and inextricably linked to all of these challenges. And of course, we can have all the goodwill in the world to implement measures, but without money to back this goodwill up, we know that it will be virtually impossible to effectively implement the BBNJ agreement. And finally, just a mention on the lack of resources for enforcing the law and proper sanctions for non-compliance that may not exist or may not be dissuasive enough or suitable to prompt the compliance with the law. So this is just a short overview. So then the next question is, how do we address these challenges? And again, there are many solutions for this, but I'm going to just share with you, again, a list of non-exhaustive examples. So first, to increase states' understanding of what is really at stake, states should map and clarify the obligations arising from the BBNJ agreement. They can do this by themselves, but there are also other means. In consultation, for example, with guides that are being prepared in relation to the BBNJ agreement. For example, the IUCN is preparing such a guide. It's also important to think not to rush the process. Implementation measures don't have to be taken all at once. States should map which obligations under the BBNJ agreement they should prioritize and then address them sequentially as possible. In relation to the legislation challenge, states will naturally have to domesticate the agreement, especially if we are thinking about dualist states. But for this process, what is really also helpful is that states map the extent of the existing gaps and shortcomings in national legislation. Also that they map potential incompatibilities between national legislation and the BBNJ agreements. And should place some efforts in harmonizing these rules. Now, in trying to devise or amend their legislation, states can also look at other states' practice for inspiration, or a model legislation that is being designed by different international organizations, seeking again to provide some form of technical assistance in this effort. So if you want to look, for example, examples of documents that have already procured to implement the BBNJ agreement, the EU, for example, has designed a draft directive in order to implement the agreement. So you can take inspiration from that. WALOS, UNEP, UNDP, they can also provide assistance when drafting legislation. In this legislative process, it is also very important then to actively, but more importantly, meaningfully engage with the general public and with relevant stakeholders, because this is important to foster an understanding of the issues at hand, but also to ensure then acceptability of the people that will have also to assist in the implementation and compliance of this agreement. When it comes to policy, again, it's important that states expressly integrate BBNJ considerations in their plans. So if we're designing blue economy policy documents, for example, again, not limiting them to national areas, but also include BBNJ aspects, especially because everything is ecologically interlinked, so it's good to have both in mind. Wait, something happened there. Okay. With respect to improving the institutional capacity and competences, it would really be advisable to institute an interministerial or an interagency consultation or commission or task force for BBNJ work. And also important to identify then, or appoint, who is going to be the lead ministry or the lead agency which will be entrusted to coordinate all BBNJ matters. Again, with the view of avoiding overlaps, miscommunications, and so forth. And in this context, is also advisable that then public authorities' roles, their mandates, their powers, their expected contributions in the context of BBNJ are clearly outlined. And this can be done either via signing the Memorandum of Understandings or via legislative amendments. Turning now to funding, in addition to allocating funds in state budget or the creation of self-sustaining regional financing schemes, like it has been done, for example, in the context of sustainable fisheries, it is also important to underline the need for African states to actively procure funding across different fronts. And there are a number of pots available. For example, the EU Global Ocean Programme, programs offered by developed countries such as Norway, and that offers this support via NORAD, and there are a number of other voluntary aid schemes that can be accessed. But it's important to be proactive in this. Will this work? No. Sorry. In relation then to human resources and capacity, it's important to map out the existing or inexisting capacity and the needs for each country. Because it's on this basis that it becomes easier to understand really where to invest in, but certainly it will be important to institute capacity building training programs, and this directed not only at governmental officials, but also for stakeholders and other relevant actors. And after this, it's also important, you know, when we train these human resources, it's important for countries to think on how to offer this personnel attractive conditions so that they manage to retain them in the country, or at least in that sub-region, because it's a big problem if you invest in education of human resources and then they leave and go elsewhere. So you need to create attractive conditions. With respect to science and technology, it will require also a significant investment, and some of it will have to come via creative manners, so trying to pool resources for multiple African research institutions to be able to have access, for example, to research vessels or other equipment, which would have otherwise, on a solo basis, be constrained because of budgetary implications. It's extremely expensive. Even, for example, us in Norway, our university has a research vessel, but it's shared amongst 3 or 4 institutions to be able to pay the expenses. Policy-wise, if governments do signal the need to establish and continue nurturing educational, scientific, and technological programs in the fields that are relevant for marine management, then it sends a very clear signal also to universities and other research institutions that they do have to create and invest also in this type of programs. And again, this, I think, examples from my own country where the education tended to be very traditional in tax law, commercial law, family law, but there was no law of the sea. So you also need this clear policy direction towards universities to change these aspects. Supporting and strengthening traditional knowledge, setting up centers of excellence, expanding training programs, developing biodiversity data hubs, and developing information sharing mechanisms will also give this aspect of science and technology a boost. When it comes to monitoring, establishing bilateral and or regional cooperation is really important. And in addition, even if some monitoring technology is expensive, states should still seek the funding for this, as well as look for cheaper alternatives and forms of technologies that can deliver at a minimum or a sufficient level of information, if only as a starting point. Then it can be incremented from there on, but the effort still needs to be done. And finally, when it comes to enforcement, states should establish new and stricter sanctions or penalties for failure to comply with legislation, or actually take a different approach and adopt rather positive approaches. In this sense, this discussion, do we give them the stick or do we give them the carrot? And perhaps trying to create some form of either reward system that rewards compliance. There are different things that can be thought of in this scenario. And in any case, on top of that, states should really also support the relevant enforcement agencies with the necessary resources and means to properly investigate non-compliance cases or to reinforce other systems that they have to control this, such as, for example, port state control systems. Reinforce this. Now, one last observation, because I think I'm running out of time, and truly assuming and hoping that the BNJ agreement does enter into force, states need, and African states really need to make full use of the opportunities created by the agreement in terms of funding, capacity building, data and information sharing, and so forth, in order to overcome the challenges that they might experience. But of course, it remains to be seen also how developed countries might attempt to undermine these efforts, and we will see this as negotiations go forth, but I do hope that African states, as they have been trying to still keep their ground and really push for their case. So thank you very much. I'll stop here. I think it's run out of time. Thank you.
Thank you very much, Maria. I think that offers us a very good way into the discussions today, a comprehensive discussion of the agreement and some of issues that have come up in connection with that. I don't know whether from the IT, whether Mrs. Khalila Hackman is online, and if she is, okay, great. Okay, I'm happy to be introducing Khalila, who is a Ghanaian diplomat and lawyer. Khalila and I started many years ago at the Ministry of Foreign Affairs in the legal department. Today she is Deputy Director of the Legal and Treaties Division at the Ministry of Foreign Affairs. She has played key roles in advancing Ghana's foreign relations, and was also legal advisor to the Permanent Mission of Ghana to the United Nations, and a member of Ghana's Security Council delegation. Khalila also represented Ghana in the Economic and Finance Committee of the UN General Assembly, that's the second committee. She's also a member of the Office of the President, was also a member of the Office of the President of the UN General Assembly during the 73rd General Assembly. Of course, many years of experience, has been involved in many multilateral negotiations, and since 2020 led the African Group of Member States of the International Seabed Authority in the development of the draft exploitation regulations on the deep seabed mining. Between 2014 and 2018, she served as alternate negotiator for the African Union flagship Continental Free Trade Area AfCFTA agreement, and has also worked on various regional, continental, and international processes. She is currently one of the leading negotiators of the BBNJ agreement for Ghana and the Africa Group. And I understand now currently in New York and joining us from New York. Cornelia, we're very grateful that you had to wake up very early to be able to join us for these conversations. And we'd love to hear a little bit about what's happening with PrepCom while you join us. Ladies and gentlemen, please round up of applause. Welcome, Khalila.
Thank you very much, and good morning to you. Please confirm that you can hear me.
We can hear you perfectly.
All right, and also confirm that you can see my screen.
Yes, we can.
Okay, so thank you very much, and I'd like to start with a few introductory remarks, beginning with thanking the University of Ghana and its partners, Norway, for this important governance conference. For us, we think that it is an important initiative as Ghana begins to elevate its discussion and national priorities around marine governance. And therefore, we welcome very much this opportunity for learning and for sharing and enhancing the government's capacity to engage broadly, both at the national and international level, on matters that relate to ocean and marine governance. Of course, it is a very wide area, broad spectrum, and therefore we also welcome very much the structure of this conference, which has sought to address various matters, brought also together various experts in the field to help share in information and experiences which are critical to the objective outlined here. And so for the Ministry of Foreign Affairs, we are both appreciative. We welcome the process. We are happy to participate both as participants and experts or resource persons to support this process. We were part of the first session. We are happy to see the second conference, and we look forward to continued engagement in this regard. Having said that, kindly give me a few minutes. I will share my presentation. You confirm that it's on, and then I'll continue from there, please.
Yes, now you're live.
Okay, thank you very much. So you have my first screen with the title, please?
Yes, we do.
Okay, that's correct. Thank you. So yes, I'm speaking on negotiating marine environment treaties from the perspective of lessons from the BBNJ process. And what I would like to do is to give a little background and rationale for the BBNJ agreement. I'll outline the state of play in terms of the status of ratifications and entry into force and where we are right now with the work of the Preparatory Commission. We will look briefly at the negotiating history. We will consider some practical experiences in terms of perspectives from the process, and then I will make concluding remarks. And I hope that with this, I would be able to share in 20 minutes what has been done in close to 20 years. And so the agreement, BBNJ as we call it, is properly titled the Agreement under the United Nations Convention on the Law of the Sea on the Conservation and Sustainable Use of Marine Biological Diversity of Areas Beyond National Jurisdiction, commonly referred to as the BBNJ Agreement or the High Seas Treaty. The treaty was adopted on June 19, 2023, by an overwhelming consensus of the member states of the United Nations, following extensive negotiations, which I would outline soon. It is important to point out that this BBNJ agreement seeks one core objective, and that is the sustainable use and conservation of marine biological diversity of areas beyond national jurisdiction for the present and in the long term through effective implementation of the relevant provisions of the UNCLOS and further international cooperation and coordination. What is also important to note here is the geographical scope, which is limited to areas beyond national jurisdiction, and therefore it extends beyond the marine territorial boundaries of member states into international waters. Now, the background and rationale for the BBNJ agreement, which was adopted in 2023, as I would say, is that prior to having the BBNJ agreement, the core elements of the agreement, which deal with what we call a package deal. Let me take a step back. The package deal is 4 key elements which the agreement addresses, and that is marine genetic resources, including questions on benefit sharing. And when we talk about benefit sharing here, is both monetary and non-monetary. And then measures such as area-based management tools, which would include marine protected areas, establishing marine protected areas, environmental impact assessments, capacity building, and transfer of marine technology. Now, these 4 core elements which form the package deal or the main pillars of the BBNJ agreement previously were formally fragmented. Any rules around it were fragmented across different rules and international frameworks and bodies, and did not respond to evolving human activities on marine biodiversity in a way that necessarily addressed the risk to the loss of biodiversity. And so the BBNJ seeks to address the gaps in international law by providing a legally binding framework, including institutional arrangements to address the concerns of marine biodiversity in a comprehensive and cohesive manner. And some people have described it as the third implementing instrument under the United Nations Convention on the Law of the Sea. Now, before I go on the Law of the Sea, now the high seas, or the area beyond national jurisdictions, which we have talked about, is an expansive ecosystems of biodiversity species. And despite its expanse and importance to terrestrial life, I think that it has faced considerable risk from illegal fishing, pollution, climate change, human activities. And therefore, protecting the high seas and that biodiversity is very much in line with global objectives for sustainable development and other economic and environmental aspirations. And that forms the background to which it was necessary to have this consolidated framework to address it. And so the treaty, as I said, built around 4 key elements, which is marine genetic resources. The treaty establishes the rules for assessing and equitably sharing the benefits, and it aims to ensure that the benefits which would be derived therefrom are distributed fairly and equitably to support scientific advancement and capacity building, particularly for developing states. Regarding the MPAs, it's a conservatory methodology or mechanism, and it seeks to also support sustainability, and it is crucial for marine life to be able to reinvent or regenerate itself towards building ocean resilience in support also of climate change. Then there is environmental impact assessment, and I'm happy to see my sister and colleague, Ms. Peace, on the stage, and I know that she would throw more light around those issues. Then the critical issue of capacity building and technology transfer. The agreement deliberately, and I emphasize that deliberately, includes provisions for capacity building and the transfer of marine technology to support developing countries to implement the treaty. Now, this is essential for ensuring that all countries, irrespective of their development status and capacity, are able to effectively participate in the objective of conserving and ensuring the sustainable use of marine resources in the high seas. And let me throw a little light on why we say it is a package deal. Now, the understanding of a package deal then is that these elements are indivisible if we should have an agreement that covers BBNJ. And during the negotiating process in the very early stages, you will see a global divide where the North was more aligned to pushing questions of access for marine genetic resource and the establishing the MPAs. Whereas from and then of course the issues of environmental impact assessment, which cut across. But for the global South, I think that a critical interest was ensuring that we could equitably participate in that process, and therefore there was a push from that side for capacity building mechanisms to form an essential or core part of the agreement. And that is why we have capacity building and the transfer of marine technology, and it is backed by funding mechanisms so that the developed countries can also support the participation of developing countries in the implementation of the agreement. Now, the BBNJ agreement is set to enter into force 120 days after the deposit of the 60th instrument of ratification, acceptance, approval, or accession. And since it opened for signature on 23rd September 2023, there are 141 signatories, the latest being Ukraine, and then 55 ratifications, the latest being St. Kitts and Nevis. 14 African countries, including Ghana, have signed the agreement. Ghana signed on the date of its opening in September 2023. And 7 African countries have ratified. These are Mauritius, Seychelles, Malawi, Cote d'Ivoire, Zimbabwe, and Sierra Leone. Ghana is currently undertaking the processes necessary to ensure ratification, and this is underpinned by the provisions of the 1992 Constitution. Let me run through very quickly the negotiating history for the BBNJ so that we see where all of this is coming in. It takes its beginnings from November 2004 when the UN General Assembly established an ad hoc open-ended informal group to study issues relating to the conservation and sustainable use of BBNJ. They held 9 meetings in a period of almost a decade. And again, in this meeting, while some were in support of a new framework, a new treaty, others felt that the issues outlined in or being proposed for discussions could be well addressed if it was tackled through implementation of existing IFBs. And this would lead to a head in 2012 when there was the Rio Plus 20 conference, and the subject came up again, and I think it emphasized the need for more work to be done around the issue. And so between 2016 and 2017, there were discussions that deliberated on what should the scope of the BB&J agreement be, how does it relate to other instruments, including the UNCLOS itself, and what really were the beginnings of the discussions around the package deal. And so in 2017, there was the outcome document, which was adopted by consensus by the General Assembly. The General Assembly then adopted a resolution, Resolution 72-249, that decided to convene an intergovernmental conference, which we have called the IGCs, to consider the recommendations of the Preparatory Commission then. The IGCs originally were scheduled to hold 5 sessions, but there was an additional session, so we have 5+, which is the resumed session, held again between 2018 and 2023, and that is what concluded eventually with the draft text of the BB&J agreement. Following the last round, that session was a very intensive session. I do recall we were up for close to 36 hours non-stop, negotiating the very final elements of the agreement in a manner that was considered balanced and satisfied the interests of as many member states as possible. Following its adoption then, what we have is a preparatory committee, again, the PrepCom, established by the United Nations General Assembly with a twofold mandate. First, prepare for entry into force, and 2, also prepare for the convening of the first conference of parties. The PrepCom is set to hold 3 sessions. We have held the session in April and in August, and we have a final session to hold in March 2026. Now, what is important to note here also that because of the status of ratifications requiring 60 ratifications, it is likely that we will have the 60 ratifications during the summit. Those are the expectations. That during the UN summit in September, we may have a few more announcements, 5 more countries remaining, which could bring us to the 60th instrument of ratification. And, you know, if you make the calculations, then it means that any time between the January and March sometime, within the first quarter or first half of 2026, the agreement should have entered into force. And once it has entered into force, and then we have about another year within which to convene the first conference of parties. And so the PrepCom right now is focused on discussions around those elements that are necessary for, you know, the agreement to enter into force. And these are around its governance structures. How do we organize the governance structures? How does the conference of parties operate? What would be its rules of procedures? What would be the terms of reference for the various subsidiary bodies established under the agreement? How is the Secretariat expected to operate? What are the financial mechanisms, and how are those financial mechanisms to be administered? And so these are very practical, intensive issues that are currently under discussion. Let me shift the focus now to Ghana's own engagement, and to say that Ghana has been actively engaged in the process of the BB&J from its very inception. And so there have been experts in Ghana ahead of myself, and those of us who are currently on board who have actively participated, contributing to the various aspects of the discussion. This has involved an interministerial department and agency approach, and it is particularly also because the agreement is very multifaceted and draws on different expertise. And because the negotiations and the work around the BB&J has been centered in the United Nations, the process has usually been led by the Ministry of Foreign Affairs through the Permanent Mission of Ghana to the United Nations. But there are the sector ministries like the Ministry of Environment, Science and Technology, the Fisheries Ministry, the Environmental Protection Authority, the Ghana National Petroleum Corporation, Ghana Boundary Commission, Ghana Maritime Authority, Ghana Navy, Petroleum Commission, and they have all participated in the process at one time or the other, making expert contributions to the imports of Ghana. Let me also add that Ghana had also adopted, like most African countries, a negotiating approach that is aligned with the African group and also with a group of 77 countries. Now, that alignment had been critical because you will see that the Africa group really made up or representing 54 countries, constitutes 1/3 UN membership and is the largest regional group, and therefore a group with much force in ensuring that we can speak and raise, our common interests. Let me also speak about on practical terms, some of the perspectives that we in the process have picked up. And I think one thing that stands out is that the negotiating of MEAs, as you would put it, be it the Paris Agreement, Biodiversity Convention, and all of those, are often backed by common purpose and ambition, as well as the political will of actors within the international system to regulate a subject or a matter that is considered not sufficiently covered under existing international law or by international agreement, as we have earlier discussed. So the BBNJ reflects a collective commitment to ensure that for the first time there is a cohesive and comprehensive legal and institutional framework to address the concerns of marine biodiversity laws from a sustainability and conservatory approach. Underpinning this common purpose is the realization that conserving the marine biodiversity is crucial to reversing the tides of climate change we are all living now, and to support the realization of other shared goals, including the SDGs, and it's not only SDG 14, but very broadly, because marine biodiversity also has implication on health, it has implication on food security, and other important goals. There is also the global 30 by 30 initiative to protect at least 30% of the Earth's land and ocean by 2030 under the Kunming-Montreal Global Biodiversity Framework. So yes, when member states can coalesce around an issue that we see as transcending boundaries and equally affecting us all in one way or the other, I think it has a way of drawing engagement and the political will that is necessary to regulate such matters as we have seen in the BBNJ process, having begun within the UNGA, moved through the Rio Conference and back to the UNGA. Again, in that same light, that process is very or intensively interest-based, and therefore one learning is that there is strength in unity, and that is the experience we bring away from regional coordination, especially in the African group, where we see that solidarization has helped to amplify Africa's voice and align the treaty outcomes with our own priorities for benefit sharing from the NGRs and access, be they monetary or non-monetary, and also in the design of the financial mechanisms so that we have a voluntary trust fund to support the participation of delegations from least developed or those countries that cannot afford to support participation. There is the special trust fund also, which will provide additional funding in addition to the funding proposed under the Global Environmental Fund. Now, this funding mechanism and infrastructure is still under discussion, but the intention, and I think that the focus of the African group and the developing countries is to ensure that there is funding to support participation and to ensure the equitable implementation of the agreement. And in that light, one thing that also then stands forth is preparedness. And it takes significant efforts to prepare ahead of negotiations and ensure understanding not only of the substantive issues on the table, but also the process and what is required at each stage. You have seen me use terms such as ad hoc committee, then there is the PrepCom, then there is the IGCs, and in all of those stages, there are dynamics around which the discussions are held, and it is important to be awake to what is required. Being prepared has also proved to help reduce divergences within the group and promote consolidated positions for negotiations. I mean, Africa is not one unified country. We have coastal states, we have landlocked states, we have least developed states, we have developing states. And so we come with a very diverse geographical and economic background. But the question is, how do we still put a cause interest that would support our common objectives and goals? Another learning and perspective is that the negotiation of the PB&J process has involved considerable time and human resource capacity. The progressive development and codification, as we have seen, almost 20 years, demonstrates that aside involving significant amount of time, it also demands participation of human resource with specific expertise in areas of international law, marine science, marine scientific research, environmental law, marine law, and the law of the sea, as well as diplomacy. It requires then that countries would commit enough resources for capacity building of these experts to ensure that they have the right mind seated at the table to negotiate, having also in mind the interests of those countries. And this underscores the point that the distinguished previous speaker was raising when she talked about prioritization. It is important that member states would prioritize, and in that prioritization, then you make a room to ensure capacity building, room to ensure funding and the political support for the participation of delegations in the process. Also, the negotiation of the PB&J agreement, as we have seen, demands a transparent and inclusive process, one that allows for wide participation of various interest groups and stakeholders, taking into account their peculiar interests and positions relative to the objective of the agreement. And so the PB&J agreement uniquely accommodates interests of developing countries, small island developing states, least developed countries, and landlocked least developing countries to ensure critical support in terms of funding and capacity building and their equitable participation in the agreement. And this is important because when you are not in the process, sometimes it is difficult even to appreciate the very fundamental basis when we talk about funding. And funding and capacity building are not just terms to throw about, but they do have practical meaning for ownership, for decision making. Because if you can't fund your participants, they are not at the table, they are not in the room, they are not part of the discussions, they are not part of the decision making process. How then are they able to benefit? And so these are critical questions that go to the core of collective responsibility and collective stewardship of the ocean. Now also, of course, it is a multilateral process that involves listening, understanding the views of everyone in the room, and building consensus. And let me point out that consensus is not necessarily unanimity. And so, yes, there are dissenting voices in the room. There are those in the room that are raising caution every time and saying, you need to be careful. Probably PB&J is not the pot of gold that you all think it is, which I think is welcome because it helps also for us to think around some of the issues that emerge and sometimes are not always in the front head, but then you come with a cautious approach based on some of these dissenting voices. But what we require is consensus that would help to reach a balanced position that is equitable without taking away from what the agreement seeks to achieve. Beyond dialogue and consensus building, I think for me, one of the key takeaways is that dialogue without action is meaningless. And therefore, beyond the negotiation of the agreement, state parties would need to take the concrete steps to ratify and then implement the provisions of the agreement in the spirit that it was initiated. We have seen some drawbacks from the Paris Agreement, and we know what that has meant for its implementation and its implications, even in practical terms. And this is where, again, we circle back to the issue of prioritization. We circle back to the issue of political will and commitment to the central theme and objective of an MEA like the BB&J. Barriers to engagement, and I think it must have come up already, and that is funding. Developing and least developing countries arising from the cost associated with travel, accommodation, and participation are key. Accessing information and the necessary expertise to participate in the process. And so far, I think the process has been designed so that member states are being supported through what is called the Voluntary Trust Fund under the UN system. This is not the BB&J because that has not come into force yet, but under the UN system itself, there is a Voluntary Trust Fund that seeks to support the participation of some delegations, and that has been quite helpful, especially from some of the LLDCs in Africa. There's also the issue of language barriers, which has a potential risk to slow the process and sometimes exclude specific language groups because, again, you're dealing with very technical issues and you want to be aligned around language. And so we see that consistently we emphasize multilingualism in the process. We want to see multilingualism in the documentation and interpretation of all official languages of the UN during negotiation process. We have had some situations where sometimes interpretation is not available, and that has meant that the process is either slowed down or you have people in the room who are not happy because they are not able then to fully engaged from a language perspective. And so it is critical dealing with the need for cross or wide range language according to the UN own mechanisms. Then there is coordination challenges, and that is what we have experienced even in Ghana from the early stages and in other countries. You would find that many countries are yet to map out and develop a national strategy for coordination of BB&J or marine issues. And that sometimes affects representation and continuity, because today you have A attending the meeting, tomorrow is B attending, tomorrow is C. You are not too sure where the mandate falls and who goes and what happens. But it's a continuous process. It's one that builds on each session is building on one. And so if you come into the room not having had prior engagement around it, sometimes it slows your own engagement. Your ability to contribute effectively is slowed down. You don't even understand why some things are being said, which to the common mind may seem not right, but perhaps it is a negotiated position. It is an agreed language. We've all agreed previously that this is how we will take this matter forward. And so you find that without that, sustained engagement and continuity over time, sometimes we do experience, drawbacks. Then also, of course, going into entry, it is important that countries will begin to think around how do we move the BB&J process forward in terms of Ghana's participation in the COP and in subsidiary bodies and at the national level. I'm happy to say that Ghana has begun some work. The Ministry of Environment, Science and Technology, together with the Global Environmental Fund, has developed a framework of implementing activities which they will be carrying out to support how or what mechanisms are necessary. They will be undertaking the necessary gap analysis in terms of our laws, in terms of our policies, in terms of our institutional frameworks, and to design a whole national strategy on how we take forward the BBNJ process. In concluding, I'd like to point out that what stands out that it is important that African countries, including Ghana, of course, will take steps to ratify the agreement and participate in the first meeting of the Conference of Parties. The first meeting of the Conference of Parties would be ceremonial, yes, would be symbolic, yes, but beyond that, it would be where critical decisions will be taken as to how you establish the Secretariat and its mechanisms, what the financial mechanisms will be, how they would operate, how the various subsidiary bodies will be constituted, who is entitled to be there, who can nominate experts, who can participate in the decision-making process. And so as state parties, countries would be legally bound by the provisions of the agreement, but then also would be in a position to participate in and contribute to critical decision-making process through the organs and subsidiary bodies created under the agreement. And this responsibility devolves from the understanding that we are stewards in common of the ocean for present and future generations. I thank you, and I welcome any questions that follow herefrom. Thank you.
Thank you very much, Helila, for this very interesting presentation. It's like taking us to the front seats of what the negotiating process has been, the ups, the downs, the unpredictable as well. And I think there's a number of things that we touched on that when we come back around for questions, I think we can answer. I think it'll be a good follow-up to her for you to join and do your presentation. Ms. Peace Beko-Kove is going to be speaking to us about overcoming fisheries management barriers for biodiversity protection under BBNJ. So this is also provides us a useful discussion point around some of the implementation issues that are going to come out from the agreement. Once again, let me remind you that Peace is a principal program officer at the EPA. She's the desk officer for Marine and Coastal Zone Management in the Natural Resources Department with over a decade of experience. She holds a Bachelor of Science and Natural Resource Management at KNUST and an MPhil in Environmental Science at the University of Ghana. She's also currently a PhD candidate at the Department of Marine and Fisheries Sciences here at the University of Ghana. She has various expertise, of course, including environmental impact assessment, strategic environmental assessment, ocean governance, marine spatial planning, biodiversity conservation, and policy development. She's also a technical member of the Sustainable Ocean Plan Working Group, technical member of the WACA Program Technical Committee, and technical member of the Marine Protected Area Technical Advisory Committee. We are very happy to have her join us, and please welcome her with a round of applause.
Thank you very much. Can you control it for me? So whilst we wait for the slides to pick, I'd like to... Next. Okay, thank you. I'd like to take this opportunity to thank the organizers, University of Ghana, and their partners for organizing this conference and the all-important conference for stakeholders to come around to once again deliberate, have discussions around the common heritage that we shared, the marine environment. Thank you very much. So earlier, as they said, the topic, I had to change it a bit. I said, why have the opportunity to talk about only one sector when you can talk about the whole biodiversity? Looking at it as Ghana as a signatory to the Convention on Biodiversity, that looks at everything coming from that I decided to tweak my topic to read, Overcoming Management Barriers for Biodiversity Protection Within and Beyond National Jurisdiction. My presentation will take us through, briefly, thankfully a lot of the previous presenters have spoken about all that you need to know about the BBNJ, the subject matter at this point. I'll just have to state that it's the BBNJ agreement, or for the long one known as the conservation, the agreement under the UNCLOS on the conservation and sustainable use of marine and biodiversity of areas beyond national jurisdiction. It's one of the third implementing agreements under the law of the sea. So this shows us where the maritime zones are. And for the past 2 days, various presenters have been talking about where we do what and why we do it there. So that's from the global perspective. So in Ghana, this is what we have when it comes to the maritime areas and the maritime zones. So we are looking at our contiguous zone, our territorial waters, and our EEZ as a whole. So the story begins from here. The areas beyond national jurisdiction. Research shows that it comprises of 62% of the surface of the oceans, and it's nearly 95% of that volume. We all know the importance of oceans to us. It plays a very key role, important role, in sustaining life on Earth. It provides vital ecosystem services such as supporting, regulating, and cultural services. It serves as a carbon sink and regulates global climate. It's also home to valuable species. And I have to say that our oceans, and for that matter, the area beyond national jurisdiction, has a rich and very diverse marine biodiversity. This slide I would like to skip because it's been handled by previous presenters. That looks about when it was and when it was adopted. The objective. So broadly, the objective under BBNJ agreement is the conservation and sustainable use of marine biodiversity of areas beyond national jurisdiction for the present and in the long term through effective implementation of relevant provisions of the convention and further international cooperation and coordination. The BBNJ agreement addresses 4 main issues, as earlier said by previous speakers. The marine genetic resources, which includes the fair and equitable sharing of benefits. Measures such as area-based management tools, that also includes marine protected areas, environmental impact assessment, and capacity building and the transfer of marine technology. The agreement also addresses a number of cross-cutting issues. That's establishing a funding mechanism and sets up institutional arrangements. It also looks at the conference of parties and various subsidiary bodies, and also a clearinghouse mechanism and a secretariat. So we all know, we've been told by this, Ghana signed on in September 2023, and the process for ratification is taking place. I decided to start from within. As a country, what do we have? What legal frameworks do we have when it comes to protecting biodiversity as a whole? So I started from the Constitution of Ghana, the 1992 Constitution, looking at both Article 36(9) and Article 41(k), with 36 having to do with the responsibility of the state of taking appropriate steps to protect and safeguard the national environment. And likewise, the second one, 41(k), Article 41(k), which talks about the obligation of every citizen of Ghana to protect and safeguard the environment. When it comes to existing frameworks for managing biodiversity in Ghana, I have tried to look at just a few, touching on the environment one. We start with our national biodiversity strategy for Ghana. The first time it was written was 2022, but the current one is 2016. Then the National Environmental Policy, then the Environmental Protection Act of 2025, Act 1124, then the Environmental Assessment Regulations, and then the National Invasive Species Strategy and Action Plan for Ghana. When you come to the fisheries sector, we have the Fisheries Act, we have the Fisheries Management Plan, and a couple of regulations, and notably among them also is a National Action Plan, a National Plan of Action to prevent, deter, and eliminate illegal, unregulated, and unreported fishing. You come to the transport sector, we have the Ghana Maritime Authority Act, we have the Ghana Maritime Security Amendment Act of 2011, Act 824, the Shipping Amendment Act of 2011, the Maritime Pollution Act, and also the National Ballast Water Management Strategy for Ghana. When you come to the energy sector, just to mention a few, we have the Petroleum Act 2016, Act 919, and then also the regulations to the Act. I have to say that these are not all the regulations that deal with management of biodiversity, but these are the major ones worth mentioning at this point. Some of the key institutions that deal with it. When it comes to the environment, we have a lot of stakeholders. These are some of the key institutions that deal with management of biodiversity in Ghana. So we start with the Ministry of Environment and its agency, Environmental Protection Agency, the Ministry of Fisheries and Aquaculture, with its agency, Fisheries Commission, the Ministry of Justice and Attorney General's Department, Ministry of Finance, Ministry of Defense, and under that we have the Ghana Navy and the Ghana Air Force, Ministry of Interior, the Ghana Police Service, the Ghana Immigration Service, the Ministry of Transport, we have GMA, and Ghana Ports and Harbors Authority. Under the Ministry of Trade, we have the Standards Authority, Ghana Standards Authority, and Ghana Export Authority. And we have the research institutions and universities. What are some of the barriers to biodiversity management in Ghana's EEZ? Fragmented governance. As the earlier slides show, we have various regulations that deal with management of biodiversity. Some target specific species, some target specific activities, and it creates a lot of room for others to not really know what to do, where to go to, and all that. Weak enforcement. We have very good laws when it comes to Ghana. Enforcing it, however, to the latter, it's a challenge. To a point, low stakeholder involvement. It takes a lot of us, every stakeholder, all hands on deck, in order to manage. We all have various areas that we need to handle or look at so that we can manage the biodiversity sustainably. It comes about also in order to manage something very well, you need to have the expertise. We have some capacity gaps, both human resource, technology-wise. And when it comes to infrastructure, how do we carry out our monitoring? Our research institutions, are they well equipped? For our defense ministry to be patrolling our waters, are they well equipped? Research institutions, regulators, do they have all that they need? And to some extent, inadequate awareness on the importance of biodiversity. I go on to say that these are not all. When it comes to fishery, we have excessive fishery effort. To some extent, inadequate data or information on biology of stocks or species. We know some, we don't know all. Some studies just target one species and then carry out research on them. But as a large ecosystem, the various trophic levels, we need to know about what species exist where, how many, what role do they play, what do we do to manage them holistically. Low levels of protection. Thankfully, under this one, Ghana is on its way to establish its first marine protected area. For now, we don't have any, but plans are well advanced to establish one off Cape 3 Points. We have limited focus of monitoring. And then our marine environment is one of the territories that we don't know everything about it. We are still learning because of other limitations or barriers mentioned earlier. How do we overcome all these barriers? Thankfully, Ghana has signed on to the BBNJ, and we are in the process of ratifying. As the previous speaker said, Ghana is participating in the PRECOM. But have we sat down as a country to conduct a national initial assessment need as to what do we want? Are the current national legal frameworks adequate enough to even go beyond? Since those we have are for within, do they cover beyond? Policy gaps for the various institutions that I've mentioned earlier. They have their individual policies. Are the policies talking to each other? How do those policies make up for area beyond national jurisdiction? Even when it comes to governance, in which office does this instrument or law sit? When that is even decided finally, that institution, has it got the administrative capacity? We need to know and find out the capacity gap assessment. As a country, we have scientific knowledge even beyond our jurisdiction when it comes to marine biodiversity. Do we know what is there? Technically, are we ready? Infrastructure-wise, are we ready to even continue combining, fulfilling our obligations under the already existing convention and subsequent laws that we have established or we have enacted for managing our biodiversity in the country? After that initial assessment, it will serve as a guide to direct us to know which policy to come up with, whether we need one or we don't. What does the policy cover? Who is involved? Is there a need to amend the existing legislations or to even come up with new ones to cover the area or the high seas? It's creating an opportunity for rights and obligations. When you read the various texts of the BBNJ agreement, there are very nice things that I'll talk about in subsequent one. Are we ready for those? Do we need them? How would we use those to our benefit as a country? In terms of capacity building and transfer of marine technology, how do we stand to benefit from that umbrella? When it also comes to the section that has to deal with measures such as area-based management, I have already said that we are in the process of establishing our first MPA. Can we explore the possibilities for establishing protected areas in the high sea? Does this look like a window opportunity for Ghana to achieve one of its targets under the Global Biodiversity Framework, the target that deals with 30 by 30? Can we use this to achieve that? When it comes to environmental impact assessment, do we have the required capacity? If yes, is there a need to enhance the capacity that we have, existing one? For sharing of marine genetic resources, how do we share it? Are we ready for that? I know Ghana is a signatory to the Nagoya Protocol that deals with equitable sharing of benefits. Have we gone a long way to achieve all that in Ghana? Funding opportunities. Who funds what? Where do we get the funding to do all that we've talked about? To conclude, as a country, the BBNJ presents an opportunity for biodiversity conservation in the area and the trickling effects we would get, hopefully, in our territorial waters. Will it help us to revive or to increase our fishery sector? Will Ghana stand the chance to benefit from partnerships under this treaty? In terms of capacity building and enhancement of existing capacities, how do we stand to leverage on that? It also serves as an opportunity for collaboration, both on the regional, national, and it goes beyond. It also serves, as I earlier said, that can we achieve our 30 by 30 by leveraging this? I conclude by asking all of us here, what role can you, as a student, as a regulator, as an industry person, someone from the research, from academia, and the general public, what role can you play in advancing biodiversity conservation in the areas beyond national jurisdiction? These are some of the references that I used for the presentation, and I end by saying a very big thank you to the management of EPA, the organizers, and to my lecturers from the Department of Marine and Fishery Science. Thank you very much.
Thank you. Thank you, Peace. I would move on to the next speaker, Dr. Alejandro Sebastian Canio. Dr. Alejandro is a project analyst and researcher specializing in marine conservation and law of the sea, particularly in relation to the Malvinas or the Falkland Islands, depending on where your politics lies. He's an analyst and project manager who works on capacity building, projects for national and international institutions. Alejandro is affiliated with CEDAPAL and UTN FRCH. He's a speaker for the Cathedra Malvinas, presenting on topics on BBNJ and environmental conservation and, of course, law of the sea. Alejandro will be speaking to us on Behind the Text, addressing the implementation challenges of the BBNJ agreement in Ghana. I've loved some of the topics we've had. We've had beyond the text, now we're going behind the text for implementation challenges. Alejandro, your audience, please round of applause.
Thank you very much for the kind introduction, Mr. Moderator. Can you hear me well?
We can hear you clearly.
Oh, fantastic. Now I'm going to share my screen. Can you see my screen now?
Yes, we can.
Okay. Thank you very much, Mr. Moderator, distinguished government officials, policymakers, academic leaders, scientists, technologists, legal and policy experts, industry leaders, esteemed guests, ladies and gentlemen. Good morning. It is a great honor to be here with you today. I would like to begin by extending my heartfelt gratitude to the Ocean Governance Research and Development Project team for inviting me to participate in this important conference. I also bring warm regards from my university in Argentina, the National Technological University of my province here in Chubut. As many of you know, football soccer is a powerful force that unites people across cultures and countries. Just as Ghana's Black Stars inspire passion and pride, football holds a special place in my country's identity. This shared love for the game reminds us of values such as teamwork, dedication, and resilience, qualities that are equally vital in our work as legal professionals. With this spirit of connection, I am excited to address a critical issue for our common future: the challenges faced by Africa and Latin America in implementing the BBNJ agreement. As a researcher deeply committed to advancing equitable and effective ocean governance, I am passionate about ensuring that governance systems truly reflect the unique difficulties encountered by developing countries. Over the past decade, I have had the privilege of collaborating closely with policymakers and experts from Latin America, Africa, Europe, and the United States. Together, we have examined how emerging international initiatives can harmonize with existing environmental frameworks and the law of the sea instruments, such as the CBD and UNCLOS. Today, I look forward to sharing these insights gained from this work and engaging in a productive dialogue about how we can collectively strengthen legal and policy frameworks in developing countries, enable them to confidently adopt or thoughtfully consider the new global ocean governance standards. Just imagine a master Bolshoi-makers workshop. Every year in spring, finely tuned, operating with precision based on centuries of knowledge. The law of the sea is pretty much like this: an established, precise legal framework that has governed ocean governance for decades. Every component fits together predictably, I would say, a dance of exactitude. The adoption of the BBNJ agreement can be likened to unveiling a new revolutionary timepiece designed to regulate the complex rhythms of ocean governance. This new mechanism introduces fresh components. And these new gears promise a more dynamic and inclusive interaction, but their integration presents challenges unlike any before. A disruptive interpretation emerged, one that loosens the familiar gears and sends the mechanism spinning into unforeseen directions. An interpretive lens reframes all laws, but as the hands move, shadows deepen. In June 2023, the BBNJ agreement was adopted, bringing new gears to this timepiece. According to most authors and negotiators, after more than 2 decades of international negotiations, the BBNJ agreement has emerged to address significant gaps in the existing UNCLOS framework. It is specifically created or crafted to protect marine biodiversity beyond national jurisdiction, an area where previous regulations have frequently proven inadequate. The agreement introduces, among others, 2 innovative legal concepts: stakeholders, and the clearinghouse mechanism. These concepts are unprecedented, not only in international law of the sea, but also in many domestic legal systems, rendering the agreement both groundbreaking and challenging to implement. To gain clearer understanding of the practical implication of the BBNJ agreement, our research centered on three key questions. How are stakeholders and the clearinghouse mechanism defined under the agreement? How are these concepts understood in developing countries? And how might the agreement influence the interpretation of the law of the sea in Latin America and Africa? This focus is specifically important because the BBNJ agreement itself does not provide any explicit definitions. To explore these questions, we used a mixed method approach. This approach includes semi-structured interviews with policymakers and legal experts, offering qualitative insights into institutional realities. And alongside this, we performed a comparative legal analysis of the treaty texts and national laws. Our study gathered data over a decade across diverse nations, as I mentioned. The introduction of new legal concepts inevitably presents institutional challenges. These innovative ideas disrupt established domestic systems, creating normative tensions. Interpreters of this agreement must adopt an entirely new approach, one that looks beyond the face of the text, digging behind or beneath it, to understand the integrated legal meanings. This approach is crucial to resolving the complexities introduced by the agreement and ensuring it functions effectively within existing legal cultures. As we move deeper, we enter an undiscovered structure of combination of articles. Here, legal certainty dims and capacity caps in developing countries become glaring. Navigating this terrain is a daunting task that calls for innovation and collaboration. While the BBNJ agreement may not explicitly reveal this mechanism on its surface, it incorporates a framework that is activated and clarified through evolving future practices. Notably, this process is primarily shaped and driven by developed countries. Although not explicitly stated in the text, the BBNJ agreement embodies what I would describe as a tunneled structure, a metaphor for the intricate implementation challenges beneath the surface, a subtle yet influential framework that emerges through evolving practices over time. This dynamic mechanism positions developed countries at the forefront of shaping the agreement's implementation, transforming it into a living instrument that adapts rather than a fixed static treaty. Recognizing this aspect is essential for anticipating future governance developments and ensuring equitable participation. The finalized text of the BBNJ agreement, both in substantive provisions and structural composition, poses considerable interpretive challenges when examined in a holistic manner. While the individual provisions may not immediately disclose a clear or linear interrelationship, within the textual framework, employing a systematic interpretive approach grounded in prevailing international operational practices, has the potential to offer a more coherent and nuanced understanding than that derived from a strictly formalistic legal analysis. The conceptual framework of tunneling invites reflection on the possibility that these provisions are not merely loosely connected, but are instead deliberately embedded within an integrated and cohesive architecture. Such an architecture may serve as a subtle yet precise instrument designed to promote functional coherence and reinforce institutional stability. Similar to the tunnel mechanism identified in other disciplinary contexts, this structural configuration appears to enable the control and secure transmission of normative influence across a complex regulatory regime. We use this tunneling metaphor to highlight the complex, opaque, and multidimensional challenges posed by the BBNJ agreement. A global submarine fiber optic cable network serves as a compelling visual analogy. This complexity renders the network difficult to manage with the interpreters, interpreters of this agreement must adopt with the complexity renders the network difficult to manage with unclear governance and implementation obstacles, resembling the experience of navigating a dense and confusing labyrinth. Recognizing and addressing these challenges is vital to ensure that the agreement's benefits are realized effectively and equitably. This slide highlights the practical challenges in implementing the BBNJ agreement. Similar to navigating a labyrinth, countries encounter complex pathways marked by legal uncertainties and gaps in institutional capacity. For developing nations in particular, the governance landscape remains opaque and largely uncharted, complicating the understanding and application of new obligations. In our research, we identified 7 distinct legal tunnels, which differ from the commonly referenced cross-cutting issues noted by many authors. The agreement outlines several key provisions, including, for example, area-based management tools such as marine protected areas, which are addressed throughout various articles. Collectively, these provisions broaden the scope of them. From this framework, it is evident that the IFBs, international frameworks and bodies, will function not merely as advisors or passive contributors, but as influential decision-making entities. The concept of planned activity outlined in Article 31 serves as a unifying element of this framework. Our research identified several key findings as well. The new institutional concepts and mechanisms introduced by the BBNJ agreement present significant challenges for developing countries, which may face difficulties integrating them into existing legal and governance frameworks. The agreement has the potential to disrupt established legal systems, creating uncertainty. This highlights the critical needs for capacity building and clear guidance to manage these impacts. This sketch appears to depict a schematic or conceptual overview of the governance structure, emphasizing the role and relationship among stakeholders, committees, and mechanisms involved in decision-making, with data as a central element. This structure emphasizes the multi-level, the multi-actor participation and institutional support critical for collaborative and informed governance processes. Developing countries often operate under resource constraints and have less experience with these multi-stakeholder processes embedded in the agreement. This may cause a slow uptake or fragmented implementation. Enhancing legal certainty and institutional legitimacy depends on equitable inclusion of all stakeholders, the state and non-state actors alike, and transparent implementation monitoring. From our analysis, 3 major findings emerged. First, the new legal concepts, while innovative, present significant institutional challenges for developing countries. Second, the agreement's novelty may disrupt existing national legal frameworks, requiring adjustment and adaptation. Third, the agreement provides new interpretive tools that expand traditional treaty law, encouraging adaptive, flexible implementation strategies that can bridge old and new governance systems. Despite these challenges, the agreement creates promising opportunities. It fosters equitable dialogue amongst all stakeholders, which is essential for building trust and legitimacy in ocean governance. It also highlights the critical need for practical tools that can help track implementation progress, and assess national readiness. These tools will be essential in ensuring the agreement is effectively operationalized worldwide. To conclude, the BBNG agreement is both a challenge and an opportunity. Like a watchmaker refining a complex mechanism, collaboration and innovation are key to its successful implementation. Developing countries have a pivotal role in shaping the future of ocean governance, yet it is equally important that they protect the unique legal identities and domestic expectations within this new legal framework. Together, through cooperation, we can navigate the future of ocean governance toward greater equity and sustainability. And finally, the story of the BBNG agreement is one of invention and upheaval, where the precision of watchmaking meets the mystery of uncharted depths. Understanding this underground structure is essential to ensuring that the clock of ocean governance ticks fairly for all. And that was it.
Thank you very much, Dr. Alejandro. I think we have a final speaker for today. I'll call on Harun. Harun is a PhD candidate and adjunct professor of political science at Kent State University. He has more than 10 years of experience in research, teaching, and advocacy in governance and politics. He served under the United States Institute of Peace as his Bangladesh country project manager. He's worked for the International Republican Institute, the BRAC Institute of Governance and Development, the BRAC University in Bangladesh, and also a core member of the National Governance Assessment Framework under the Prime Minister's Office in Bangladesh. His main research interest areas are on issues of governance and development at the BRAC University in Bangladesh. Harun will be speaking to us today about opportunities and challenges. We're having a South-South perspective. So he'll be speaking to about opportunities and challenges in implementing the BBNJ agreement from a Bangladesh perspective. We hope that his experiences and his viewpoints would also enrich our own perspective as we discuss the way forward in respect of the BBNJ agreement. Harun, is Harun online? Can I get an indication from the IT team? No, it's not online. Okay. Then, I would open up the floor for questions at this stage. We have heard interesting presentation. First, the keynote address by Professor Maria. We have also heard from Khalila Hackman on the negotiation process and some of the lessons from there. Peace has spoken to us also about biodiversity protection in areas beyond national jurisdiction. And we have also heard from Dr. Alejandro about implementation challenges connected to the BBNJ agreement. If you are in the audience, if you have any questions, please raise your hand. The mic will come to you immediately. Any questions? We have Professor Nunu here. Can bring the mic down here. There's another. For him, there's another hand up there. So we'll take all the questions, responses, and then we break for lunch.
Okay, thank you, moderator. My question goes to Peace. She can answer the question, so no problem. Yes, I know she can do it. What will trigger the assessment, the needs assessment, the capacity assessment for the BBNJ in Ghana? What will trigger it? Also, the second, and who will do it? Who will do it? Which institution do you think? Is it EPA, or who will do it? Or Fisheries Commission, or why hasn't it started? Yeah. The second question is to you, and also, if you look at the strategy that 2018, we said that Ghana so far we are exploiting only the continental shelf, and beyond that, all the way towards the high seas is like a free zone. So we have not exhausted our EEZ, and beyond that, it's a de facto marine protected area, sort of. Yeah. So the question is this: that can't we start adding that to achieve our 30 by 30? Thank you.
Thank you. There's another hand there at the back.
Thank you, Mr. Moderator. I think Prof. have touched on my question, but I still go ahead and ask some of them because I have a lot of the questions. Marine research laws, that's one that hit me, and I think we have to look into it. Because when I was doing my PhD research work, yesterday I mentioned that I did about 12 kilometers into the sea. And I have a discussion with somebody from the US, and he was telling me that before I can go that far, I should have seek risk assessment before they can even allow me to go. So we need to have this policy in place to kind of protect we, the scientists, that go that far into the sea to conduct research. Then my next one go to Peace, my sister. You talk about the gaps and the barriers that are within the research system. Now, for us, I think the first research vessel that Ghana youth will have, I think, at Topolov, we're going to this BBNJ kind of, it's called for a lot of, attention and then financial commitment. I'm saying this because going to sea is not child play. You need a lot of funding before you can go to sea. So as Prof said already, within the nearshore areas, we have not covered much. So going forward, for us to be effective in this BBNJ affairs, data is data-driven, because when you stand, you have to talk, and what back you is the data. So what are some of the policies? We touch on all, and I'm happy that you mentioned the financial ministry is also involved, and then we, the researchers in the university, we are also involved. So what are some of the financial commitment from the government sector, so it can enable us to carry research to have the data that will be very available for you to implement some of these BBNJ that you're talking about. Thank you so much.
Thank you very much. Is there any other question? Okay, there are two hands there.
Thank you. The second speaker talked about the Sustainable Development Goal 14, life below the watershed. And I want to know how that one is in the BBNJ agreement, how it marries in the BBNJ agreement.
How the BBNJ agreement marries the Sustainable Development Goal?
Yes, thank you.
14, okay.
Thank you. My question is to Dr. Peace. You made mention of weak enforcement, and I want to ask that to what extent do weak enforcement mechanisms under international law hinder biodiversity conservation in areas beyond national jurisdictions? This is the case, Article 87 of the UNCLOS, United Nations Convention on the Law of the Sea, made mention that states have the freedom to fish on the sea. But the CBD says that biodiversity must be conserved and sustainably used. Now there's a conflict because industrial fishing fleets over overexploit fish in ABNG. UNCLOS allows fishing, but CBD obligation is to conservation are weak outside national waters. So I want to know to what extent does that affect biodiversity? Thank you.
Thank you very much. There's a hand up here.
Good morning. My name is Nana Kwesi Amachi Bedu Pokumensa. I want to find out from Madam Peace what the EPA is doing to prevent people from polluting the Ghanaian waters. Thank you.
Thank you very much. I think probably that's the last. I'll take two questions on my end. First one is to Maria. Maria, I think one of the bigger questions that come up consistently in African audiences is the idea, and I think Professor Nunu suggested a bit about that even domestic capacity vis-a-vis the oceans in relation to areas within national jurisdiction is a challenge. And so isn't there a question of regulatory overburdening of African states in joining such an agreement and even ratifying it? But also secondly, where is the agency? Where did the agency come from? You know, there's no exploitative capacity in many states. There's no capacity to implement in many states. So where did the UN prioritize this agreement as something that we need to bring forward? Khalila, if you're online, I think one of the interesting questions I remember when the process was ongoing was that many people were talking about the US's role, overwhelming role in the negotiation process. And one of the key things people were talking about is that the same thing happened during the UNCLOS negotiations. And when UNCLOS was negotiated, the US refused to ratify it. And in the BBNJ process as well, they were very influential in holding back agreement on certain key things. How frustrating was it from a negotiator's point of view when everybody was clear that the US was not going to ratify the agreement and yet was a key holder in the negotiations? How is it for you from a practical perspective as a negotiator? Is it frustrating? How do you deal with that in the negotiating process? And then also finally to you, Khalila, it would be interesting to hear a bit about how the African states collaborated and also be able to hold consensus on certain points during the negotiation process. I know that in this agreement, the African group was very united in terms of the positions it took. Were there a lot of internal divisions, or was it a more smooth process as we saw from the outside? Thank you. Maybe we'll start from Khalila because you are up early, and then we come to those who are here in the room.
Okay, thank you. Can you hear me, please?
Yes.
Okay, so I will start with the first question on how the BBNJ agreement supports the SDG. And again, I had said not just 14, but others, and let me demonstrate that. I think that the BBNJ, as we have said, provides that framework for conservation and sustainable use of biodiversity. And it allows for the creation of new marine protected areas. And the marine protected MPAs are a conservatory tool for allow area-based management. And what it allows is that you give room, or you delimit certain areas within which there will be no activities at all, so that you do not disturb the ecosystem in that particular place. And being able to do that for the first time in the high seas means that you are expanding the reach of states towards preserving or conserving biodiversity, and that in itself is a contribution to the goal 14. But in preserving biodiversity, because we're talking of an ecosystem, what it also does is that it enables regenerative activities in the ocean, which means that you are helping other species, including edible or food. You are enabling species that support science, that support pharmaceuticals, that support the production of all kinds of genetic resources that are used in the field of Science and Technology. And so this intersection and ecosystem arrangement is why we are able to draw on the point that if we were able to implement the BBNJ agreement, it would have ripple effects going into the SDGs, going into the 30 by 30 global initiative. Of course, also there is the mechanism for environmental impact assessments, which means that activities within the area necessarily will require an impact assessment to be conducted by the state, and to make that report available to all member states, who can now assess and also say that yes, you have taken necessary adaptive or mitigatory measures to ensure that the environment is not harmed or seriously harmed in undertaking the activity that you are doing. So that is how we look at it as an ecosystem approach. Now, secondly, also on the question about U.S. participation. As you know, for treaties, you are not bound until you have ratified the agreement. And so, of course, whilst we know what the practice of the U.S. had been, until the agreement enters into force, nobody knows whether they will come on board. And it is a fact, then it remains speculatory from their posture that you do not expect them to come on board. The difficulty with MEAs is the polarization of interests when it comes to ocean resources, and managing that can be very tricky. But it's also important to be aware of where everybody stands, and that helps in how you negotiate your own position. You know where your alliances are, you know where you can draw on for collaboration, you know where you can draw on for support. And of course, for every binding agreement, for any nation that is entering into that agreement, you are entering on it based on your own interest. That interest may be political, that interest may be power play or power-based. And so we've seen these dynamics in the Paris Agreement, we've seen it in other places, and we believe that it's the same thing that is playing out. We will eventually know what the full impact would be, but it is the reality, and that's why I said you cannot always have unanimity, but ensuring that at least you have a balanced approach that serves the wider interest is the way to go. In terms of collaboration within the African group, let me say that it has also taken time, and like I said, it has involved taking into account the specificities of the sub-regional groups in terms of our own economic groupings and our own geographical groupings and the level of interest. I mean, when you are talking BBNJ, how do you expect a landlocked country that is facing economic hardships and sometimes civil and political unrest to be interested in taking delegations to go and sit and talk about the ocean when they really do not have access to the ocean in the first place? And so managing those divergencies is not a very easy thing, but what it has meant is that we have consistently ensured engagement. And so prior to going into that room, we sit together, we develop positions, documentations are presented. This is what is on the table. Can you share it within your regional group, the sub-regional group? What is SADC saying? What is ECOWAS saying? What guides us? What are our existing policies and approaches to some of these things? And that's what helps in formulating our positions. And so sometimes the position is not one, but you may have 2-3 positions which we all coalesce around to push so that we ensure that we are covered. The African Union has not got a BBNJ position per se, but we have had support from the observer mission of the African Union in the UN, where they have consistently supported capacity building projects, programs. We've had workshops, we have training sessions, we have preparatory sessions ahead of each meeting, trying to build positions. And let me say that we don't have consolidated positions on everything. And where we do not have those positions, countries as sovereign members of the United Nations with a voice can very well take the floor and have sometimes taken the floor to express and push their own national interests. We don't see it as an opposition. We see it as a way of fostering, a specific interest and helping everyone to benefit as much as possible from the agreement. So that is what I would say. But before I go off, let me just say that Malaysia has just announced the signing of the agreement, and therefore it brings the number to 142. And that announcement came in just a few moments ago. And this, of course, further enhances the universalization of the agreement and its implementation going forward. Thank you.
Thank you very much. And before you run away, I know that you are pressed for time, but I wondered if you could share thoughts on what do you think is Africa's biggest gain from a negotiation point of view in this agreement? What are the things that you feel like Africa won in terms of the final text?
I would say that, and again, all elements really, like I say, are indivisible. So the win in itself is that package deal of having all the four pillars going together without taking any away. What is the essence of capacity building if you are not going to be using that capacity building for the purposes of accessing MGRs? Or what would be the purpose of IEAs if you are not going to have activities in terms of, access for the MGRs or other research mechanisms? What is the purpose of the institutions if you are not going to be there to participate? And so it is a holistic agreement. It is comprehensive. I think it is good that we take it as one bulk. But in that negotiation process coming towards it, I think that the push to ensure that we could be part of the process, we could have an equitable agreement, we could ensure the legitimacy of the agreement because we had been part of the process. And in that regard, participation was critical, and ensuring capacity building mechanisms, ensuring that the global north will go beyond to support Africa, and not only Africa, but developing states' engagement in the process, I think was critical. Some have warned that the BBNJ could only be aspirational. Could be, but again, it depends a lot on the political will and commitment of all member states to push it forward. And you ask, what is the urgency? The urgency is our lived experiences today of the impact of biodiversity loss. And the earlier we act, the better for us all. Thank you.
Thank you very much. Much appreciated. A round of applause for her. I think you're probably going to take leave of us, but we appreciate you joining us. I want to, before I go to the next questions, panelists, I want to acknowledge also those who have joined us online and who are following the session. Maria, maybe you take the next question before we go to peace. Is that working? You can use mine.
Well, Oliver, you extended me the same question on agency and overbearing African states, and again, that's why I also included that question in my presentation. Why should African states do this when it can have so high costs, and it's not an easy process? And given other concerns that African states have. But again, you have to think of, what are the consequences of not ratifying this? And it is, in terms very much in the long-term ramifications of not conserving and using the resources properly in areas beyond national jurisdiction will also have very real effects to areas within the jurisdiction of African states, will affect their ecosystem services, their socioeconomic developments and so forth. So it is in the interest of African states to really engage with the BBNJ agreement and to push for its ratification. Of course, the benefits that come with the ratification, again, will only be achieved to its full potential because a lot of it hinges also on the participation of the developed states. It's very much contingent to that. So also try to address this problem, or what it also requires in terms of agency, is for African states to continue with their united position in trying to form these alliances and trying to coax other states to ratify, so that we have a meaningful representation of states that enable the BBNJ to work. Because otherwise, again, yes, if we rush, if we don't have a number of states on board, if we can't make it work, then yes, African states might have lost a lot of time and resources for nothing. But that's what we want to avoid.
Let me follow up here. One of the things generally that happens, of course, once an agreement is ratified or signed or completed, is that we all start to rally around the agreement. But of course, even in the negotiation process itself, there's so many disappointments as to what the final text become. I wonder if you have any thoughts on what you were disappointed that states did not go too far on, or anything in that regard you want to share?
No, well, it's always difficult in international treaties, right? Because we do want to have the best possible, most solid agreement that would really be strong in terms of conserving the biodiversity, in terms of giving the most possible benefits to all developing states, landlocked states, etc. But we know, again, this is a battle of interests. It's impossible to please everybody. And again, yes, it's not the strongest agreement that I would have liked to have seen, but it was the possible agreement. So we can't just look at it in negative terms because we didn't achieve exactly what we want. It's better to have this rather than to continue with the situation of having relatively ungoverned high seas and the area in terms of biodiversity conservation and use.
And maybe finally, I know that the questions are coming up more and more about climate change and the ice and all of that. You're working in the Arctic. I wonder if you have any thoughts to share as to whether you think another framework agreement or so specifically targeting maybe the Arctic and other areas is important, or you think that sufficiently we have enough framework that allows us to go there?
Yes, for many years that question has been discussed in the context of the Arctic. Do we need to create an Arctic-specific agreement that will address problems of environmental protection, climate change, and so forth? But again, the general consensus is this is not the correct approach, because there are a number of international agreements and frameworks, be it under the Law of the Sea Convention, Paris and Climate Conventions, environmental agreements, that do apply to the Arctic. The Arctic is not special in that way. It is a region like any other, and there is a vast network. So what we rather prefer, instead of trying to, again, more costs, more time, negotiating new agreements, is to use what is already in place to make it work better. So that is the focus in the Arctic.
Thank you very much. Peace. I know that everybody was coming out for you today. So
thank you very much. So I start with Prof's first question that has to do with who does the initial assessment. From where I sit and information available to me from my ministry, that's Ministry of Environment, Science and Technology. They are in the process of conducting that. Plans are far advanced to source funding to carry out this initial assessment. So for now, that is what I can say about that with respect to who does the initial assessment. As to who in person, I don't know. But for the ministry, that is what I have from my ministry. I don't know about what is happening in other ministries. Then the second one, Prof, you and I wrote that MPA strategy. But you are asking me, why do we want to go beyond our jurisdiction when we are not done with what we have, even as at now? The good news is that it's not automatic that the area beyond your jurisdiction is yours. Any other country can come and claim it. So for this area-based management, if Ghana or Ghana ratifies it and domesticates it, it serves as an opportunity to collaborate with other countries that might decide that this area, after Ghana's EEZ, is for marine, they are trying to establish a marine protected area. Why would we sit down and watch them take it? It's one of the opportunities we can use. It will help us as a country. We stand to benefit from all the capacity training that comes under it. When you read the text of the agreement, it spells out what needs to be done, who benefits, what they benefit from. It's, from my perspective, we don't have to let go of such an opportunity. We can explore it as a country to help us achieve other obligations under other conventions. Then the next question had to do with risk assessment, asking who does the risk assessment for research. Most of the policies that we have are a bit quiet on that, even when it comes to research. But as academics, what do we say? We are stakeholders when it comes to policy, drafting of policies. Don't you think this is the time that when we are called to help with the drafting and during stakeholder consultation, we can make inputs that a section should be dedicated for such a thing? It's for us to consider the research institutions, the universities, and even for regulators. Do they create funds that can serve this purpose? Will industry support? These are the many questions we need to ask ourselves and find solutions to them. The other one has to do with data-driven. For us to take informed decisions, we don't need to be walking blind. Those times have changed. We need to know what is there, where is it, in what quantity. We need to answer all the WH questions. Which, where, what, and then even come out with how to do it. So we need to go on to it. And then my colleague asked about prevention of pollution and vis-a-vis marine pollution when it comes to an institution. From my presentation, I talked about the two articles, one starting with the state, and then the one as a citizen. So between me and you and everyone here, the onus lies on us to prevent pollution generally. When it comes to waste pollution or the management of plastic waste or waste in general in Ghana, it falls under the Ministry of Sanitation. They are mandated by law to manage waste. As an authority, we have also come out with some guidelines for management of the various types of waste, be it from electronic waste, health waste, and it goes on and on. We also have some regulations that falls under the Hazardous and Electronic Waste Control and Management Act, subsequent regulations that deals with how various types of waste, including plastics, are managed. I will not end without talking about the National Plastics Management Policy that aims at creating a framework to reduce plastic pollution and foster a circular plastic economy by promoting recycling, reducing waste, and creating green jobs. And talking about creating green jobs, there are some initiatives currently going on. When you refer to GRIPE, which stands for the Ghana Recycling Initiative by Private Enterprises, they are piloting recycling efforts across the nation by creating buying back events or centers where plastic bottles, single-use ones, when you are done with it, you send it back to them. NGOs, notably among them trashy bags, converting waste into other uses. And it goes on and on and on. As an institution, we always celebrate Oceans Day every year in the month of June. And we always create awareness on how to prevent and manage our oceans. So we are still working, and we are working per our mandate. We have to work with you collaboratively. So it is up to all of us and not up to just the institution to control waste management in Ghana. Thank you very much. I think I've captured everything. Okay. Thank you very much.
I was holding my breath the way you were holding the mic. I wasn't sure where to land. But thank you very much again, and everyone, for joining us for this conversation. A round of applause again for the panel. I do hope that you're able to grab lunch and then join us for the afternoon session, which is about developing legal framework for marine plastics. And the way forward, it will be the final before the closing ceremony later today. For those who are, pardon? Yes, we were back in an hour. Same place at 1 o'clock, so we can close early. Thanks everyone again, and I appreciate you having a fantastic audience. And see you in the afternoon. Yes, the panel, please come. Let's take a picture together. And everybody else, we can take a picture outside after this. Thank you.
To help me do this, our keynote will be done by Prof. Aleke Stephen O'Brien. And with me here, I have Dr. Ingrid Andreasen and Professor Edem Mahu of the Department of Marine and Fisheries Sciences. Professor Aleke Stephen O'Brien is an associate professor at the World Maritime University in Malmö, Sweden. Her research interests include law of the sea, marine environmental protection, and sustainable ocean governance. Prior to joining the World Maritime University, Prof. O'Brien served as the Federal Environmental Agency of the Federal Republic of Germany. She has extensive professional experience at the Secretariat for the Convention on Biodiversity, Montreal, Canada, the University of Trier, the Marine Unit of Directorate General Environment of the European Commission, the United Nations Institute for Training and Research, as well as the WHO Europe representation to the EU. Dr. O'Brien has also been participating in the intergovernmental process towards the development of an international plastic treaty under the auspices of the UN Environment Programme as part of the delegation of the International Maritime Organization. Her research work has been to participate in numerous international scientific collaborations, including the co-convening Chapter 12 on marine debris and dumping of the United Nations Second World Ocean Assessment. She has also contributed to the Economist Plastics Management Index. Dr. O'Brien currently serves as the convener of a working group of the International Standard Organization Technical Committee on Marine Decarbonization, as well as working group on legal aspects of the ocean atmosphere interface of the International Surface Ocean. She is strongly engaged in teaching at WMU as well as other universities on subjects such as public international law, law of the sea, and ocean governance, among others. She has been an invited lecturer to the Yosu Academy of the Law of the Sea, UN Dualos Fellowship Program, as well as the Philippine Law of the Sea Academy, among others. She is a lead negotiator of a global agreement on the management of plastic waste. Dr. O'Brien will be presenting on developing a global legal regime for marine plastics, reflections, and the way forward. Ladies and gentlemen, Dr. O'Brien. She's online.
Thank you so much. Thank you for these kind words. And I'm really glad I can join you online. I'm so sorry that I cannot be there in person, but it's been very busy in the plastic world, so to speak, and I'm going to fly off tonight. Thank you so much. I would like to share the screen now, and I would like to to confirm that you can see it. Share. Oh, hold on. Oops, slideshow. Can you see my screen? Can you hear me?
Yes, we can. Please go ahead.
Good. Thank you so much. Thank you for the kind introduction. And I would like to thank the organizers very warmly for the invitation. It's always a pleasure to work with you, and I was really happy when I got the invitation. Before I start this discussion or this presentation today, I would like to acknowledge that, as you mentioned, I was part of the International Maritime Organization delegation, and as such, I have to be neutral, but I wear two hats. I wear one as I'm an official, but I'm also a researcher at the World Maritime University, which is established under the International Maritime Organization. And as such, I can be a researcher and give my opinion. And today, this is what I'm doing. I'm here as a researcher for the World Maritime University. And thank you so much for the organizers again. And also, I'd like to acknowledge the role of the donors that making this really exciting work possible. Ghana always comes up in my professional work, be it the plastic treaty negotiations. I have students right now who are excellent who come from Ghana. And yeah, I would love to travel to you one day. Before I continue with my substantive discussions and ideas, I would like to quickly introduce the World Maritime University. We are a postgraduate university based in Sweden, and we offer master and PhD programs for students from all over the world. And we have actually, in my class, there's only students from the Global South, and we are working on sustainable ocean management, maritime law and policies. And this might be really interesting for people who would like to pursue a master's degree or a PhD degree. Please, this is a warm welcome to get in touch with me. What I'd like to frame my discussion today is about the triple planetary crisis. I heard really interesting talks this morning, and I'm quite jealous of the people who work on BBNJ because they already have an agreement to work with. And what we are seeing here, also with plastic pollution, is that we cannot think isolatedly how we address pollution management. We need to think systematically and understand that the climate change, biodiversity loss, and pollution all collectively put so much pressure on the Earth's well-being that we need to find integrated solutions and need to be brave in addressing them. And we have made major steps with the BBNJ agreement, with the advisory opinions, and I'm reflecting a little bit. Do we see this also in the plastic treaty negotiations, which, spoiler alert, we don't see as much? Before I start, I know this might be a little bit introductory, but I would like to highlight the diverse amount of plastic we are dealing with if we're talking about plastic pollution. We have single-use items, we have like illegal or mismanaged waste and landfills, cigarette butts are made from plastic, containers are sort of type of marine plastic and also contain a lot of plastic potentially when they go overboard, plastic pellets. And then something I'd like to pick up, and I saw that this is also topic of today, is fishing gear. And this is something that has been actually quite an agreement in the plastic treaty negotiations. There was even in the beginning a standalone article on fishing gear in the plastic treaty itself, in one of the drafts that we have, and we had many. But the idea is that fishing gear are so impactful to the marine environment, to navigation, that they will be quite an easy part of the plastic problem to address. We have moved away a little bit from that, but I would like to highlight that fishing gear is still very high on the agenda. And why do we need to have a plastic treaty at the moment? What we have is, and I will talk about it a little bit more later on, a very fragmented regulatory landscape when we talk about plastic. And this is against the scientific or like economic reality that plastic is a very cheap material, you can use it, it might help to alleviate impacts of climate change like droughts, or if you cannot drink water, you need to transport water in plastic canisters. And I know in Ghana you do that as well. And we have an expected increase in demand of plastics in the next 70 years. And for the Middle East and Africa, and I do hope you can see this on my screen, it's the yellow prediction of how much the Middle East and Africa alone as a continent will demand for more plastic itself, for products, for lifestyle, for hospital care. What we see is a correlation between demand and plastic pollution. At the moment, we have estimation that 8 to 16% of the plastic production will end up in the marine environment. And these are just very conservative estimates. So there is a correlation between the demand of plastic and the production, and then therefore the pollution in the marine environment. And to address this, we are currently negotiating a plastic treaty. And I put the really long title on because I want to be complete here. We are working towards the plastic treaty negotiations within the Intergovernmental Negotiating Committee on an internationally legally binding instrument to end plastic pollution, including in the marine environment. And I'm so sorry, I would call it now plastic treaty negotiations, but I would like you to know that there is a committee established under the United Nations Environment Programme that has the mandate to address this specific problem. And I know, bear with me, I have an onion now at the screen, and I know we are at the Law of the Sea and Ocean Governance Conference, and the onion is definitely not a marine species. But the onion, I think, depicts absolutely correctly what we have been experiencing. So when we started out with the thought, oh, we maybe need a plastic treaty to embrace the different sectors, the different materials we are looking at, it looked like, yeah, we can handle it. And you know, if you look at an onion, it's brown, it looks a little bit, dare I say, I'm so sorry, boring. You know, you can manage it. It feels like a manageable. It doesn't feel like a wicked problem in the beginning. And then when you start working on the onion, different layers are exposed. And for us, it was starting about what do we mean by pollution? We had then health considerations. We had justice consideration, coming about differentiated responsibilities in there, climate change. So step by step, you are peeling, you are discussing. And in psychology, they also use the onion as a layer to expose the beginning. You hear the words of people, then maybe you hear their intention. And the more you peel the onion, you become to the beliefs and the values of people. And that is really interesting, because what we are right now in the negotiation phase is we have peeled off all the layers. We are at the bare entry point of the onion. And where it's good, we have not really reached to really chop that onion up and put it into a pot. Because, you know, when you cut an onion, while you're doing it, you might cry a little bit. You're wondering, why am I doing this? But once you put the onion in the food, it will make all the difference. And we all know food makes people come together, and you share a nice moment. An onion will most likely make it better. So that is my framing now for this discussion we are having. The mandate that was given by the back then United Nations Environment Programme in 2022 was to develop an international legally binding instrument on plastic pollution based on a comprehensive approach that addresses the full life cycle of plastic, including provisions to promote sustainable production and consumption of plastics. And I have here, and I hope you can see this, sort of an outline of how a plastic life cycle approach would look like. This sort of wave of plastic life cycle looks very different depending on the delegation and the regions and groups you're asking at the plastic treaty negotiations. Some people say, we need to look maybe towards the end. Others say we need to look from the extraction, so from fossil fuel, the chemicals that used in it for the fracking to work with the oil, to plastic production, design, and then also the users, consumers, and then what are we doing at end of life. Others have sort of a middle ground version of that. And it is clearly that this discussion is not at all where we thought we would be. And at some propositions were actually further away from the mandate that was provided now than it was in 2022. The idea was that by now we would have had a plastic treaty. And it started in 2022 with the United Nations Environment Programme. And the idea is that, and also very heavily supported with really strong people from Ghana to develop that within the framework of 2022 until the end of 2024, 2.5 years. We met in Paris, in Uruguay, in Kenya, in Canada, in Nairobi, and in Korea. And the idea was that in December last year we would have an agreed treaty. However, the divergence on life cycle, all these kind of things were so different that the idea was we cannot agree on a plastic treaty right now. Let's call in for a second session of the fifth meeting of this Intergovernmental Negotiating Committee to adopt a treaty 2 weeks ago. And you know, when I accepted the invitation, I thought that would be great to this conference. It would be a great moment to reflect on the new plastic treaty, to develop my thoughts about it. And unfortunately, I cannot do that. And to say that I'm not a little bit burned out and tired would be an understatement. I think we all, including your very, very skilled co-convener of the Contact Group 2, Dr. Derry from Ghana, he did fantastic work in trying to move people, delegations and groups in one direction. But I will give you an example where we stand right now, and it's been very, very challenging. So anyone, particularly the BBNJ agreement colleagues who went to the negotiations, know that brackets in international negotiations are signs that there is a disagreement. And brackets are signs that countries or delegations and groups do not agree on something, and then you say, we put a bracket here because we don't agree, let's move on, and we can come back to that. We moved into the session where we were supposed to agree on a plastic treaty now in August with the chair's text that was adopted in December last year with 379 brackets. 4 days into the negotiations, we had 1,351 brackets. And that gripped the European Commissioner to say, there's more brackets than plastic in the sea. I mean, it's a little bit overstated, we know this, understated. But it was quite challenging to see that we couldn't even agree on the names of articles. We couldn't agree on articles. We couldn't agree on what is life cycle of plastics, for example. And I'm not going to go into the details of this specific article, but this article was supposed to be on plastic products and has changed and has so many different hats on right now. So it's actually quite difficult to understand where are we standing even. So in essence is that it's been quite difficult to see where we are. And the big questions we are facing are, I've just put 3 because it would be, you could write a PhD on the problems, is how to define the plastic life cycle. What is plastic pollution? Does it also include regulating plastic themselves and not only plastic pollution? Are we focusing on only certain aspects in the life cycle, like production, use, or end of life? Or are we also using chemicals and climate change aspects? And then something that Ghana was very strong is the inclusion of human health and justice. And how do we develop obligations that go beyond the environmental impacts? What are social impacts? What are economic and health impacts that we need to address through obligations? Or will it only be an environmental treaty in essence? And who's impacted by plastic pollution? Who's benefiting from action or inaction? And Dr. Derry was responsible of convening an contact group on where the delegates discussed just transition as a standalone article. So this was a very, very demanding part of the work. And how does the common but differentiated responsibilities principle look like? So how do we, and then the next point is finance mechanisms and how we map onto existing international agreements. And this is where I would like to take you on a little journey for the law of the sea and then come back to some reflections. So we know that the plastic treaty that we are trying to, and we have not given up yet, we're trying to adopt, is part of the global architecture of public international law. And plastic pollution has been very fragmented into chemicals, waste, trade, human rights, food and health, bit of regulation everywhere. And the UNEA resolution really strongly confirmed the need for cooperation, coordination, and complementarity among relevant regional and international conventions. And that's why we have been faced with the everlasting challenge to insert a new instrument into a really already populated area of law that still has quite a lot of fragmented and fragmentation gaps within it. So to propose my framing now, I would like to address 3 hypotheses from my presentation now. And the first hypothesis is a new treaty may bring greater clarity over the environmental obligations under the UN Convention on the Law of the Sea with regard to plastics. But if not done well, it also risks adding an unwelcome layer of complexity to the existing regime. And the regulatory relevance of the potential plastic treaty in relation to the UN Convention on the Law of the Sea derives first from its material scope, which includes different sources of marine plastic pollution, which we see in both, mainly the discussion on vessel source pollution, so fishing gear and plastics. There's also some discussion on dumping, land-based pollution, and interestingly enough, not very much on atmospheric introduction, which we know is a huge source increasingly. And then as well as the potential institutional arrangements, so monitoring, reporting, compliance. How do we add that on to the plastic treaty, to the UN Convention on the Law of the Sea, and vice versa? And then finally, I argue that the proposed means of implementation of the plastic treaty, so the financial means, the capacity building, may also be guided and indeed further substantiated and amplify existing provisions under the UN Convention on the Law of the Sea on capacity building, Article 202, and technology transfer. A very interesting and I think a great regime of rules and rules of reference, where the UN Convention Law of the Sea makes reference to standards found elsewhere in public international law to set the normative threshold for state action. And a very prominent one is reference to the IMO, International Maritime Organization's instruments on vessel-based pollution or dumping, for example. And there's an own dedicated article, 237, paragraph 2 of the UN Convention on the Law of the Sea, which allows the marine pollution regime to evolve in light of new or amended standards. And it says that specific obligation is assumed by states under special conventions with respect to the protection and preservation of the marine environment should be carried out in a manner consistent with the general principles and objectives of this convention. And this convention is the UN Convention on the Law of the Sea. So we have this mutual exclusiveness that UN Convention quite smartly maps onto existing and very more technical regimes. And I would have loved to explore this exactly point with you in this presentation. However, I'm not able to do this because we don't have substantive obligations yet. What I can tell you is that fishing gear will be in there, and pellet loss and pellet management. These are at the moment, I feel like there's a very strong support for that, but it might be also moved out of the substantive body and moved into an annex. I mean, who knows? But I would like to highlight that since we also will have a fisheries presentation later on. So what we have through these rules of reference is a normative reinforcement by the UN Convention on the Law of the Sea, and a very strong reference to the due diligence obligations to protect and preserve the marine environment. This is even more relevant after the advisory opinions from ICLOS or the International Court of Justice, for example, and I saw that you addressed that already. And even though there's no clear of what generally accepted international rules and standards could be, if the Plastic Treaty would establish such a standard and rules and standards, it would give the Plastic Treaty immediate effect, and that the parties to the UN Convention of the Law of the Sea will have to at least take into account these standards. But at this moment, I don't see that these are specific enough, for example. And now just to reflect a little bit on INC 5.2, and you can see already how, when I say I would have loved to talk about where we're going, as similar with the BBNJ agreement, and I heard today Kalila, I think, talk about this. It was a day and night push to get the treaty over the line, and when it was announced that it was not happening, given the many divergence issues, it was a very, very difficult moment for everyone. And I think a lot of delegations from small island states had to then go to the BBNJ committee to New York. So it was a lot that was going on. And what I would like to reflect and highlight on is that I do hope that, so right now where we are standing on the shoulders of giants. What we have achieved is the result of decades long of research by scientists, by very brave government officials who are able to speak up, by lawyers who come up with the idea that we need to translate these kind of impacts into a regulatory regime, and by very strong non-governmental organizations who are very brave to really address the core, to be public about it. And I do hope that in 10, 15 years, someone will say that they will stand on the shoulders of us giants, of us little people that become one big giant that enable change in the future. And what have we achieved so far? Something that I'd like to highlight, and I really learned so much as well as a researcher, is that the nexus thinking. So in the beginning, I mentioned the wording was about plastic pollution, including in the marine environment. Originally, it said marine litter. And while we are peeling this onion away, it was clear that plastic pollution, the chemicals contained in it, affect human rights. They affect workers. If we are changing, if we're limiting certain uses of fishing gear, material in fishing gear, this will affect workers. So the Just Transition article is of key importance in this regard. And what we also have faced much more prominently now is discussion around conflict of interest. What's the role of industry? What is the role of scientists? How do we participate in that? How we have a meaningful engagement in the development and implementation of public international law. We had a good point that we have really strong youth delegates, delegations met with them, engaged with them, and the red lines of groups became very clear where they said, we will not accept this. This one is not a waste management treaty. It has to be the entire life cycle. And there has been very strong scientific evidence the last 2.5, 3 years that have come about, particularly in regard to human health. And something that has been missing is a huge opportunity, in my opinion, to really capitalize on the advisory opinions of the International Court of Justice and the International Tribunal for the Law of the Sea. A lot of researchers and NGOs said we need to integrate it. There was very little mention on climate change overall in the suggestions for text propositions. And what we also felt is that the present treaty negotiations was set, it is set in a very challenging geopolitical time, and proxy conflicts from other situations, other parts of international law were put on the table and actually found the way into treaty regime where plastic might not be the right fora. And something that is very, very disappointing, there was a suggestion on a standalone health article, because the plastic and the chemicals contained in the plastic we know are toxic, carcinogenic, but it has been removed for the sake of trying to push for adoption of the agreement in August. And a specific biodiversity language article has also not found its way into the treaty yet. And I would like to close my discussions not on a so gloomy out sort of finish, but I would like to quote Kofi Annan with this absolute fantastic quote. And he said, "We have the means to pursue our highest aims. We have the knowledge, the wealth, the tools and the talent. Our great challenge is to summon the will of the world. Our enemy now is indifference. The belief that there are many worlds and that the only one we need to care about is our own. That belief is false. It is a delusion. There is one world and one humanity." And I wish that Kofi Annan could stand with us and remind us every day where we're going with this. So with this, I'd like to thank you so much for your time and attention.
Thank you very much. Our enemy is indifference. I know we all know what plastics are doing to our oceans. Otherwise, we won't be here. Otherwise, it won't be a topic for discussion. Let's all come together and make a difference. Our next speaker, it looks like it's an all-ladies affair this afternoon. That wasn't the plan. The singular gentleman, unfortunately, had to be elsewhere. That is why it seems like it's an all-ladies affair. But it's not bad, is it? Okay. So our next speaker will be reviewing marine plastics and fishing gear. She is in the person of Dr. Ingrid Andresen. She's a legal scholar whose research primarily focuses on the law of the sea, fisheries law, environmental law, and the governance and regulation of environmental impacts. Her work spans a broad range of environmental legal issues connected to the fisheries sector, sustainable transitions, ecosystem-based management, and the implementation of legal frameworks at both national and international levels. She also maintains a strong interest in fisheries law, more generally, as well as international environmental law and human rights. She earned her doctorate with a dissertation charting the implementation of the ecosystem approach to fisheries in tuna regional fisheries management organizations, challenges and opportunities for future conservation of non-target species. This research included a detailed case study on how states can strengthen regional cooperation to promote more sustainable fisheries management with particular emphasis on the duty and responsibility to reduce ghost fishing. Her academic approach integrates both doctrinal legal analysis and empirical legal research, and she actively engages in interdisciplinary initiatives that bring together law, policy, and environmental sciences. In teaching, she contributes to courses in special administrative law, environmental and resource law, equipping students with knowledge at the intersection of law, sustainability, and resource management. Dr. Andresen is a member of the Norwegian Center for the Law of the Sea, where she collaborates with colleagues on cutting-edge research addressing pressing issues in ocean governance. Through her research, teaching, and publications, Dr. Andresen continues to shape academic and policy debates on sustainable ocean governance, advancing the integration of legal, environmental, and human rights perspectives in fisheries and marine resource management. Ladies and gentlemen, Dr. Andresen.
Okay, great. Good afternoon, everybody. Thank you so much for that kind introduction. I would like to begin this presentation just as my colleague Maria Das Neves did this morning. We're very grateful to be present here in Ghana for the hospitality and also for the cooperation between our institutions. We deeply value that. So today I'm going to be talking about marine plastics and fishing gear. And when you look at the title, Review of Marine Plastics and Fishing Gear, it means that it's going to be a bit technical because I'm going to flesh out the legal framework regulating fishing gear. So bear with me. Marine litter is described as one of the most pervasive and fast-growing alterations of the world's oceans caused by humans. Among its sources, abandoned, lost, or otherwise discarded fishing gear, commonly referred to as ALDFG, represents a significant contributor to marine litter. Scientific studies have highlighted the gloomy fact that ALDFG accounts for up to 76% of all macro debris stranding on beaches, that 46% of all plastics observed in the North Pacific consists of lost, abandoned, or discarded fishing nets, and that 80% of all long lines in certain areas of the Eastern Mediterranean are lost, leaving substantial amounts of fishing gear in the marine environment. ALDFG undoubtedly poses significant threats to the marine environment. It presents a risk of entanglement, commonly referred to as ghost fishing, where the gear continues to function without human control. It also represents a risk of ingestion for marine life. It contributes to plastic pollution, and it causes damage to benthic communities and habitats. The impacts of ALDFG have thus been regarded as posing serious threats to marine ecosystems, comparable to the harm caused by bycatches discarding, and also habitat destruction. And it is also worth noting that the impacts of ALDFG have intensified over the last decades, driven by the rapid expansion of fishing grounds, as well as the transition to more synthetic, more durable, and more buoyant materials used for fishing gear. And research has indicated that fishing gear can take decades to naturally degrade in the marine environment, thereby prolonging its long-term ecological consequences. ALDFG is increasingly being recognized as a pressing and growing global issue. Marine litter is currently being described as nearing the critical point of no return and a problem without borders. And consequently, the need for robust legal and policy responses is evident. If we take a closer look at recent initiatives to tackle and regulate marine plastics stemming from fishing gear, it is inevitable to avoid the recent negotiations for a plastics treaty, which keynote Professor Aleke Stephen O'Brien introduced earlier in this session. And we all know that these negotiations did not lead to the adoption of a legally binding instrument at the time being. And I will come back to how this also actually represents a missed opportunity to enhance the regulation of ALDFG effectively. However, it is worthwhile noting that the UNEP, in its zero draft of 2023, in the preamble and in the chair's text of 2024, incorporated provisions aiming to regulate ALDFG, as also Professor Aleke Stephen O'Brien mentioned. And for those of you who haven't read the chair's text of 2024, fishing gear was explicitly included in Article 7 on releases and leakages, and Article 8 on plastic waste management. It was also included in Article 8 of the draft text, which was presented on the 15th of August during the intergovernmental negotiation session held in Geneva, demonstrating then the need to effectively address ALDFG. And further, as late as in 2023, the UNGA, United Nations General Assembly, urged states and regional bodies to develop effective mitigation measures to minimize the impacts of ALDFG on the marine environment. Similarly, the European Union identified fishing gear as a major source of marine litter, accounting for up to 27% of the total litter in the Union when formulating its directive on the reduction of certain plastic products on the marine environment. And then the International Maritime Organization, the IMO, is also a significant contributor to these initiatives. And some of the current initiatives include the organization's action plan to address marine plastic litter from ships from 2018, which aims to enhance existing policy and regulatory frameworks and introduce new supporting measures. And all these recent developments, in my view, reflect the growing commitment of the international community to minimize the impacts of ALDFG, particularly in the broader context of marine litter. So then we're turning to the question of how ALDFG is currently regulated and what the existing legal gaps are. The issue of ALDFG is located in the intersection of international fisheries law and marine pollution law, which makes it subject to a fragmented legal regime that involves a variety of legal instruments and regulatory actors. While the IMO has a broad pollution-related mandate that includes pollution from fishing vessels, the mandate of the Food and Agriculture Organization of the United Nations, the FAO, and Regional Fisheries Management Organization also contribute by developing global and regional standards for fisheries. So starting from the top with the overarching legal framework applicable for ALDFG, we have Part 12 of the Law of the Sea Convention, which we have discussed in several panels at this important conference. Although the Convention does not make any explicit reference to ALDFG, Article 192 of the Convention obliges state parties to protect and preserve the marine environment. And this obligation includes taking all necessary measures to prevent, reduce, and control pollution of the marine environment from any source in accordance with Article 194, first paragraph. The term pollution of the marine environment is defined in Article 1, fourth paragraph of the Convention as the introduction by man of substances into the marine environment which results or is likely to result in deleterious effects. And ALDFG clearly falls under the scope of this definition, as it represents the introduction of substances by man into the marine environment which is likely to result in such deleterious effects. And thereby, ALDFG also qualifies as being pollution under the Law of the Sea Convention. This then means that states are required to take all necessary measures to prevent, reduce, and control pollution caused by ALDFG in accordance with Article 194. However, Part 12 of the Convention does not specify the measures that states must adopt to fulfill the obligation per se. But in accordance with Article 211, first paragraph of the Law of the Sea Convention, which regulates pollution from vessels, states are obliged to establish international rules and standards to prevent, reduce, and control pollution of the marine environment from vessels. These rules shall be developed through the competent international organization or general diplomatic conference. And it is widely acknowledged that the IMO represents the competent international organization in this regard. The International Convention for the Prevention of Pollution from Ships was adopted by the IMO in 1973 and later modified by the 1978 Protocol, commonly referred to as the MARPOL 73/78. Annex 5 of this instrument provides a regulatory framework for preventing pollution by garbage from ships, including fishing gear. As of May 2024, MARPOL Annex 5 has 156 contracting parties, which represents 98% of the gross tonnage of the world's merchant fleet. So it's widely ratified when we're thinking about the global perspective. And it's also undebated that Annex 5 of the MARPOL falls within the scope of generally accepted international rules and standards in accordance with Article 211 of the Law of the Sea Convention. The MARPOL Annex 5 consequently establishes an operational framework for minimizing ALDFG by prohibiting discharge into the sea of all plastics, including but not limited to synthetic ropes, synthetic fishing nets, in accordance with Regulation 3.2. In accordance with Regulation 8.1, the MARPOL also requires the establishment of adequate facilities at ports and terminals for the reception of garbage. And this serves the purpose of preventing such garbage from being discharged at sea. Annex 5 also encompasses Regulation 10.6, which emphasizes that the accidental loss or discharge of fishing gear, which poses a significant threat to the marine environment or navigation, shall be reported to the flag state in cases where all reasonable precautions to prevent such loss has been taken or where the gear is, for example, discharged for the safety of the ship or its crew. The MARPOL 73/78 is widely regarded as the most important building block for regulating marine pollution from ships, giving practical effect also to the provisions of the Law of the Sea Convention. And by falling within the scope of international rules and standards, all state parties to the Law of the Sea Convention are also obliged to adopt laws and regulations in relation to garbage from ships that have at least the same effect as MARPOL Annex 5. In addition, ALDFG is regulated under the dumping regime encompassing the London Convention and the London Protocol, insofar that the disposal of fishing gear at sea constitutes dumping. And the term dumping is defined in Article 1, 5th paragraph, letter A of the Law of the Sea Convention as any deliberate disposal of wastes and other matter from vessels. And if fishing gear is dumped during fishing operations, such actions will represent a breach of the obligation to prohibit the dumping of any wastes or other matter in accordance with Article 4, 1st paragraph of the legally binding London Protocol. Additionally, obligations relevant to minimizing ALDFG are found in the legal framework regulating fisheries. Article 5 of the 1995 UN Fish Stocks Agreement encompasses several obligations aimed at conserving the marine environment. Among these is Article 5F, which requires states to minimize pollution, waste, and catch by lost or abandoned gear. As legally binding obligations, states are required to actively implement measures to achieve the objective of both minimizing the catch caused by LDFG and the waste and pollution generated by discarded fishing gear. We also have Article 18D of the Fish Stocks Agreement, which legally obliges state parties to mark fishing gear for the purposes of identification, functioning then as a preventative measure which may lead to less ALDFG, as ownership may be detected if fishing gear ends up at sea. And in the context of regional fisheries management organizations, we also have Article 10C of the Fish Stocks Agreement, which obliges state parties to adopt and apply generally recommended international minimum standards for the responsible conduct of fishing operations, in fulfilling their obligation to cooperate in high seas fisheries. And this is interesting because what represents such standards applicable to ALDFG? The non-binding FAO Code of Conduct certainly falls within this formulation, and the instrument recognizes that states and regional fisheries management organizations and RFMOs, which we remember was introduced by Professor Nuno yesterday, so I'm not going to go into details about them, but we can reflect back to that presentation. Yeah, so states and RFMOs should adopt appropriate measures to minimize pollution, waste, catch by lost or abandoned gear through measures including, to the extent practicable, the development and use of selective, environmentally safe and cost-effective fishing gear and techniques in accordance with Article 722G. And furthermore, states should introduce and enforce laws and regulations based on the MARPOL in accordance with Article 8.7 of the FAO Code of Conduct. So here we see the creation of a bridge between the fisheries and pollution framework in this voluntary instrument. And quite interestingly, the FAO has also adopted several guidelines relevant for minimizing pollution from fishing gear, including the voluntary guidelines for marking of fishing gear and guidelines on bycatch management and reduction of discards. And I will, in my next slide, explain what measures that can be derived from these different instruments. So if we take a closer look at the concrete measures that may be derived from all these instruments, we end up with the following measures applicable to minimize ALDFG. So we have first here the implementation of a prohibition on discharge of fishing gear at sea in accordance with the legally binding MARPOL framework. The implementation of a prohibition of dumping of fishing gear at sea in accordance with the legally binding London Protocol. Establishment of gear disposal systems in landing places in accordance with MARPOL. identification of gear ownership in accordance with the 1995 UN Fish Stocks Agreement, and also the FAO voluntary guidelines on the marking of fishing gear. And furthermore, another relevant measure found in the legal framework is the establishment of reporting mechanisms for ALDFG in accordance with the MARPOL, as introduced earlier, and also the FAO voluntary guidelines on the marking of fishing gear from 2019. And finally, procedures to systematically recuperate lost gear, which is derived from the FAO guidelines on bycatch management and reduction of discards, and also reduction and elimination of plastic pollution by using biodegradable materials, which is stemming from the same guidelines. And I want to stress here that this list, which you see on the screen, is by no means exhaustive, but it's based on the relevant measures which can be identified in the legal framework. Scientific studies have highlighted other measures of relevance, such as bottom mapping to prevent snagging of fishing gear, etc., but they're not on this list. And I would also like to stress that the identification of these measures illustrate the previously mentioned fragmented approach currently permeating the overall and combined framework regulating ALDFG. We have several different instruments regulating the issue at stake, both legally binding and also non-binding. And furthermore, the identification of these measures also demonstrates that the regulatory responses to minimize ALDFG is actually quite well developed, including both preventative measures to prevent fishing gear from entering into the marine environment in the first place, such as prohibiting discharging, prohibiting intentional dumping, and also the establishment of gear disposal systems. But we also have what is known as curative measures, focusing on removing ALDFG, which has already entered into the marine environment, such as procedures to recuperate lost gear and reporting mechanisms. The regulatory framework for ALDFG has been described as robust in the legal literature, and I agree that the framework is indeed comprehensive in some respects. But where are then the gaps in this puzzle? They lie in the actual implementation and enforcement of the identified measures. And I will show you a brief illustration showcasing the issue at stake. This example, which we're using here, includes the 5 tuna RFMOs and their implementation of MARPOL 7378. And we are using the MARPOL as an example, as this instrument has almost global coverage. These 5 RFMOs, which you see here on the screen, they actually cover approximately 91% of the high seas ocean surface, thereby playing a pivotal role in ocean governance and fisheries management. And Ghana is a member state to the ICCAT since 1968. And why is the example of tuna RFMOs so relevant? It is because the previously mentioned Article 10C of the Fish Stocks Agreement requires states to implement generally accepted international rules and standards to fulfill their duty to cooperate in high seas fisheries. So it's not sufficient to just implement this or domesticate it under national legislation. It must also be implemented through these regional fisheries bodies. And as I also mentioned, the MARPOL represents such a standard. That's undebatable. So, if we are looking into then the adopted conservation and management measures of these 5 RFMOs, it becomes clear that only 2 out of the 5 tuna RFMOs have, for example, adopted measures prohibiting intentional discarding of discharge of fishing gear at sea. And that is the ICCAT in 2019 and the WCPFC a bit earlier in 2017. And this finding in itself represents a considerable gap that 3 RFMOs have not adopted this such measures, it represents a considerable gap when reflecting upon what is required as a matter of international law and what is currently being done in and by these organizations. Another example worth mentioning is the establishment of suitable gear disposal systems in landing places, where only one RFMO, the WCPFC, have adopted such a measure for its member states. And only one of the 5 tuna RFMOs have adopted obligations requiring all their member states to implement reporting mechanisms, and that is the ICAT, reporting mechanisms for lost gear. And quite interestingly, the IATTC and the CCSBT has not adopted any of their required measures derived from the legally binding MARPOL, then again demonstrating significant gaps in the implementation of the legal framework. And this is my last slide. Based on the mapping of the legal obligations applicable to regulate ALDFG and the identified gaps in implementation, using the example here in this presentation of the 5 tuna RFMOs, which I would also like to stress is not at all a unique example, it becomes clear that we still need strong regulatory or strong responses to effectively minimize ALDFG. And I personally believe that adopting a global framework to end plastic pollution, including in the marine environment, significantly will strengthen the efforts to minimize this problem. As demonstrated by this presentation, the legal framework currently governing ALDFG is fragmented and not necessarily easily accessible precisely due to this fragmentation. This is primarily because there are different actors currently developing these legally binding and voluntary obligations. And by including ALDFG in a global instrument regulating plastics, we will most likely see a more coordinated effort to minimize plastic pollution from fishing gear. In the meantime, important also to stress that states need to commit and strive to implement the measures that at present can be identified in the legal framework. Further development of the implementation of these instruments may also represent a step forward to enhance efforts to minimize ALDFG. And here it is very important to stress that the obligations are there, the legal framework is there, but we clearly need to focus more on implementation. ALDFG currently accounts for up to 61% of marine litter in the open ocean, and the need for action to mitigate this pressing issue is evident. We need to do something to minimizing the impacts of ALDFG, and we need to do so now. And I will end my presentation here. Thank you so much.
Thank you very much, Dr. Andreasen. I'm sure you will all agree with me that we have a lot of laws. If you didn't know that, I believe this conference has enlightened you to the laws that are available. So, what is the problem? After the presentations, we'll have this discussion. The next presentation will be done by Professor Eden Mahu. She's an associate professor of marine biogeochemistry at the University of Ghana. Her research spans paleo-environmental reconstruction, ocean carbon dynamics, anthropogenic chemical stresses, nature-based solutions, and coastal resilience. She co-leads the Ocean Margins Initiative, part of the Schmidt Sciences OBVI framework, which is developing an integrated observing and modeling infrastructure for the Gulf of Guinea. She currently chairs the OMI Laboratory, a state-of-the-art research facility at the University of Ghana, which was established under the Ocean Margins Initiative. And this serves as a regional hub for marine science, enhancing the university's capacity for cutting-edge research, interdisciplinary collaboration, and training of future ocean scientists. Her distinguished achievements include receiving the 2022 AGU Africa Award for Research Excellence in Ocean Sciences and the 2021 National Geographic Emerging Explorer Award. She holds fellowships from both the AU, EU Arise, and Royal Society FLAIR programs. Prof. Mahu champions global ocean science equity through leadership in UN Ocean Decade Capacity Development, including co-chairing Vision 2030 Challenge 9 and steering the Capacity Development Facility. She also serves on boards like Coast Predict, Global Ocean Core, Equisea, and Ocean Best Practices. She has helped build West African research infrastructure and leads the BIOTA and convened the 2023 West Africa Marine Science Symposium. And I must add, she's from my department. Ladies and gentlemen, Professor Eden Mahu.
Thank you very much, Dr. Winisoa, for that generous introduction and for adding that I'm from the Department of Marine and Fisheries Sciences. Good afternoon to you all. And before I start my presentation, just by show of hand, who in this room think they've eaten plastics before? Who? Let me just see by show of hands. Okay, good. And who thinks they've never eaten plastic before? Oh, I see one hand at the back there. Okay. All right. So my talk this afternoon is supposed to be on microplastics in the marine environment. But you see, I put my favorite picture there because when it comes to humans, in order to find solutions to problems, we have to try and connect the problems to ourselves. Then we see how serious the problem is and why we should be worried about it, because a lot of people sometimes think that, oh, if plastics are in the ocean, why should I be worried about it? That is why we keep seeing a lot of plastics going into the ocean. But it is not a problem of just the ocean. It's a problem that is connected to us, to our future, and to future generations that are yet to be born. Okay. Yeah, so I believe that a lot has been said this afternoon, and if I bring us to our own local context, I'm sure if Dr. Derry was here, he would have mentioned that to us, that Ghana produces about 840,000 tons of plastic waste annually. And out of that, we are only recycling 9.5%. What happens to the 90.5%? What happens to all that? Where does it end up? And it will interest you to know that macro plastics in the form of macro, meso, or micro constitutes 85% of marine litter globally. And when you even come to Ghana, it will interest you to know that it constitutes more than 85% of the marine litter. So without systemic change, plastic flows to the ocean are projected to rise substantially by 2040. We are almost there, and currently we are catching more plastics than fish. So now to my topic, microplastics. What are microplastics? Microplastics are plastic particles that are less than 5 millimeters size, in terms of size range. So if you want to picture 5 millimeter like the head of a needle, it's very small. You cannot see most of these plastics. So any plastic that falls below this range is considered as microplastics. And there are two primary types of microplastics. We have the primary microplastics, which are the intentionally made microplastics. These are made for industrial purposes. Even for some of the big plastics that we see, they are produced from these primary microplastics. And we also have them in cosmetic products. There's a lot of awareness around this now, and globally there's been a lot of efforts to ban these microplastics that we find in cosmetic products. Then we have the second type, which is the secondary microplastics, which are just, as the name suggests, they are from the broken fragments of larger plastics. So where do the secondary microplastics come from? They come from synthetic textiles, packaging waste, the styrofoam boxes that we use, mismanagement of waste, fishing gear, and second-hand clothing, which has gained a lot of popularity over the past few years, because we know that Ghana has become a hub. I think it's among the three countries globally that import a lot of second-hand clothing. And a lot of these clothing come in very bad shape. And these clothing are made of polyester, most of them. And when you go to Kantamantu, you see a lot of, we have the different grades, grade 1, grade 2, up to the bottom. The ones, those that are not good are just discarded into the environment, and they end up shredding. You go on the beaches, you find a lot of these second-hand clothing on our beaches. In terms of pathways, so where do they, how do they get to the coast or the ocean? We have rivers playing a role in carrying the land-based plastics, so rivers and storm water. Then we also have the wind, which also plays a role in spreading the microfibers. Then we have the wastewaters. And then in terms of exposure routes, you can think about ingestion. So that was why I asked the question, how many of us think we've eaten plastic before? We are eating plastic every day. Through inhalation, so as we even sit in this room, we may have microplastic particles in this room that we are likely to be inhaling. So microplastics do not only pose ecosystem risk. There's a lot of evidence now that human beings, we cannot run away from the fact that we are consuming microplastics. But the sad part of it is that we are even finding it in human organs like the placenta. Imagine a young child who is yet to be born, and the very organ that is carrying this, surrounding this child is carrying microplastics. Recent studies have found microplastics in the heart. We found them in breast milk, and also recently in human blood. So that means that we all need to worry. I've talked about the exposure pathways, how we think that we are likely to be getting these microplastics, but in terms of the toxicity, there's a range of toxicity or potential health impacts, like oxidative stress, DNA damage, organ dysfunctioning, but these are all potential. The research is still ongoing to help us understand the long-term impact of these microplastics on human organs as well as on fish. So that is just an introduction to what the problem is and why we should worry about it. I'll now just take you through some of the studies that we have done to document microplastics in our environment. So evidence of microplastics in seafood. We've looked at microplastic in a number of organisms from the ocean, but I'm just highlighting a few of them for us. We've looked at microplastics in the mangrove oyster. The oysters are organisms or animals in the ocean that are known as ecosystem engineers, and basically they do a lot of, they eat by filtering from the water column. So if you want to see the amount of microplastic that you have or the amount of any pollutants that you have, they've been suggested as very good bio indicators of environmental health. So we looked at oysters from the Gambia, Sierra Leone, Ghana, Benin, and Nigeria. For each of these oysters, we just digested their whole tissue and isolated microplastics. We found a total of 780 microplastics in the whole tissues of all the oysters that we looked at. And we saw very high numbers in the oysters that we got from the Gambia. So when you are looking at microplastics, you want to understand what types of microplastics are there in terms of the morphology. And we found it was interesting to find out that for all the oysters that we looked at, the microfibers dominated the counts that we had. So you realize that there were a lot of microfibers in the green in all the oysters from the various countries that we looked at. And what could be the source? Dr. Ingrid talked about abandoned fishing gear. In fact, we suspect that in the Gambia, that is one of the main source of the microfibers that we're seeing in the oysters, because in the estuary that we sampled, we saw some evidence of, a lot of fishing happening, but also some evidence of fishing gears that have been discarded just anyhow there. Then in terms of the polymer fingerprints, what polymers are there in these microplastics that we're looking at? We saw 3 main polymers, polypropylene, polyethylene, of course, dominated. We found polyester, which, gives us some kind of a clue that some of the microfibers we are seeing may be coming from clothing. We found nylon and polyamide. But if you look at the polymer composition, then it's likely that a lot of these fibers that we're seeing were coming from fishing gear, because a lot of the nets that they use are made from the polyethylene and also the nylon materials. Okay, then we also did another study where we now looked at, we went from the estuaries, we went away from the estuaries and went into the ocean itself. We collected some seafood from Nigeria, and we looked at, so this is fish, and we looked again at microplastics in this fish. We looked at the gut. And for 160 fish that we sampled, this is the total number of microplastics that we counted, 5,744. There were a lot of microplastics in these samples. And if you look at the distribution of the morphotypes, you see that we had a lot of things that we suspected to be microbits. And of course, these are fish that dwell around the bottom. So sometimes, depending on which habitats of the ocean the fish is coming from, you are likely to get certain types of microplastics. And even with respect to pollution, if the fish is close to the bottom, it has more contacts with the sea floor, and we have a lot of pollutants that get buried in the sea floor, and so you expect that once they are feeding around that area, they will be taking up a number of pollutants and contaminants in addition to the microplastics. Size is also very, very critical, because if you are looking at the toxicity, how toxic the microplastics are or are likely to be, then you need to also take the size into consideration. Chances are that the very big plastics will be able to go through the gut. However, the smaller size ones are the ones that have the potential to go through cell walls. And so these are the ones that you are likely to penetrate and go into the blood, because they have to cross a boundary to be able to, get there. So we found that these are the different polymer, the different microplastic sizes that we found, and we detected very small sizes below 100, which in a way is okay for human health and toxicity purposes. Then we also looked at the intake. So based on those samples that we collected, we wanted to estimate how much plastics those who love fish, may be taking on an annual basis. And so we use a formula to do that. And because this is coming from Nigeria, we had to use the Nigeria annual fish consumption rate. So you look at the annual fish consumption rate in an adult population, and you use that to do the calculations. And for some, for milk, I'm not seeing properly. Okay. Yes, so for a fish like the Mugelcephalus, for example, an adult Nigerian man or woman is likely to consume about 178 pieces of microplastics through the consumption of this species on an annual basis. So depending on the size, the type that you are consuming, that is what is likely to determine the long-term toxicity implications of what you are consuming. But this is just to give a snapshot of how much you are taking in and whether you think you are eating plastics or you are not. So that is microplastics in seafood, but we also looking at microplastics in the environment itself, where we are looking at seawater, estuarine water, and this is some of the preliminary results that we are getting from the environmental samples that we are collecting. This final one is, we just recently started the Ocean Margins Initiative project, and as part of the project, we are trying to start a microplastic monitoring program. And so far, again, in the water samples that we are collecting, it points out to the fact that we have a lot of fiber, microfibers in the seawater samples that we are collecting. We found a few of the other types of microplastics, but the fibers are dominating most of the samples, in most of the samples that we are analyzing. Yes, so policy and management and legal framework, I think a lot has been said, but for me, I think that little drops of water makes a mighty ocean, so we all need to act as individuals at the individual level. We need to reduce the waste that we are consuming, and ideally, when we come for conferences of this nature, we should see more of, dispenser type of drinking water, where we can come with our bottles and refill when we need to. Microplastics are difficult to clean in the environment, so you want to even make sure that they are not going there. But now we have a lot of them in our system. From our homes, when we wash our clothing, they are shedding off through the washing machine. And so we need to upgrade our stormwater and wastewater treatment facilities, and try as much as we can to catch or capture a lot of the fibers that we are releasing from our clothing. At the same time, when we are applying MAPL and other legal framework to tackle the problem at sea, we also need to find a way to tackle it on land-based issues. Then we also need to monitor. We need the data, to know if it's improving or whether it's getting worse. Many countries have enacted bans on microbeads in cosmetics, and I think that it's about time we all start going that direction. There are a lot of technologies that are coming up. So when we even think about the blue economy, the tech opportunities within the blue economy, I think that we should also think about innovations that can help to clean the microplastics that we are finding in the ocean. We have the coral ball technology, which I have seen, that we put in washing machines, and the idea is that it collects all the fibers that are shedding off your clothes when you are doing the laundry. And then at the end, you take it out, and then your water can go through your drainage without any plastics. And then, of course, awareness is also very, very crucial in this campaign or in this call. Thank you very much.
Thank you very much, Professor Mahu. It's time for us to discuss now what has been presented to us. I believe that plastics are not an abstract thing to anybody because we all experience it, we all see it. So this is a time for you to ask all the questions. We have a bit of time, so please, let's ask all of them, all of the questions on your mind. Any questions from anybody? Yes.
Yes, thank you very much. My question could go to the last speaker. I don't know whether by policy in Ghana here that you see people collecting plastics and selling. Is it that what they get from it is not enough for them to encourage them to do more? Or the punitive aspect of our laws is also not going well, so that people will be throwing plastics anywhere? So that is what I want to look at. That is it encouraging to probably looking for plastics and selling, so that by so doing we will be able to keep our environment clean. I want to know that. Thank you.
Okay, good afternoon. I think that's a very insightful presentation so far. My first question or set of questions is to Dr. Ingrid Prof. To what extent do liability frameworks, I'm sure you touch on quite a number of the legal frameworks on UNCLOS and then MAPOL. To what extent do these liability frameworks exist for ship owners or fishing companies when their gear becomes marine debris? And also, how can legal frameworks incentivize the retrieval, recycling, or proper disposal of fishing gear? And if these exist, how do we ensure compliance and enforcement? Because in your closing remarks, you indicated that we need a global treaty to ensure these. But with the existence of liability frameworks and legal frameworks, how do we ensure first enforcement and compliance even before we graduate to the global treaty? And then my second question is for Doc on microplastics. The very presentation that we will listen to now. In Ghana, we were told, or we heard, whether it's a rumor, on plastic rice. Is there something like plastic rice? Is it a rumor, a hoax, or a myth? Is there some significant research on plastic rice? If there is or there is not, is there also research on microplastics in our rice? I'm sure microplastics also find their ways in rice, just as you mentioned of the others. And if they find themselves in imported rice, how do we ensure, that is Ghana Food and Drugs and the Standard Authority ensure that the rice that we are consuming does not have microplastics? Thank you.
Please kindly let us know your name and where you are coming from.
Okay, my name is George Osufojo from Petroleum Commission.
Yes, so to the first question, whether it is encouraging to pick plastics from the environment, I think that it is encouraging and is becoming quite lucrative for those who engage in this activity. Hitherto, when you dispose of your plastics, you realize that these plastics are just the way they are in the, how do you call it, the litter or the bin that you are disposing them of in. And then they are picked up by the waste management trucks. And then they go to the landfill sites. But what I am seeing these days, even within my neighborhood, is that people intentionally put plastics, bottles in front of their, how do you call it, their gates, and people come and pick them up. And when you interact with those who are collecting the plastics, they tell you that there's a market for it now. I don't think that we are fully there yet as a people, because we need to upgrade our recycling infrastructure. If we have a lot of recycling infrastructure as a country, then this becomes even more lucrative. But as it stands now, we are still not there yet. But there are people who are earning some sort of living from it. So I think that what we need to do to really help these people is to find a way to even sort the litter at home. So that if you know that Mr. A will come around and come and search through your bins trying to pick plastic bottles, why don't you just gather it and then let him know? So when he comes, can pick it and then go and sell it. That is, if you don't need it. Ghana has a national plastic management policy that is set to be implemented, or we are probably even implementing it already. And in that policy, we have things like extended producer responsibility. We have things like you buy the plastic and then you take the bottle back and get some money from taking the bottle back to the distributor. So if you think that you don't need that penny, you could put it together and give that opportunity to these people who are going around and collecting the plastics. If we do that, then we make their work a bit more easier and more effective for them. But I think that it's encouraging. We only need to upgrade the infrastructure or invest more in the recycling bits of things. Then the second question was on plastic rice. The truth of the matter is that I have not conducted any study to ascertain that we have plastic rice on our markets. It was a bit of a rumor that we all heard, but I haven't done that. But I would also not say that it doesn't exist, because probably we haven't taken the pain to research this. We should be very, very easy to actually do if we want to know whether the rice is plastic or not. We just need to do the FTIR analysis on the rice, or even we can use simple microscopy, fluorescence microscopy, to just examine the rice to see if it's plastic or not. So I think that's a good area to look at, to research into. But also the other suggestion or comment on microplastics in rice, I think that is also something that is very doable. Like I said, the exposure pathways are different. We have microplastics in the air, and we are bagging these plastics in rooms that probably have microplastics in them. So what shows that we can't find microplastics in the rice that we are consuming. It's a matter of taking the pain to do the research to ascertain some of these facts. I don't know if I've answered all the questions, but I'll pass it on to...
Yes. Is the microphone on? Yeah. Okay, thank you so much for those very interesting questions. To start with your first one about ship owners and private companies and potential regulations there, then we're on a different side of the laws. We're in the private maritime law. What I can say is that I know that some states have started these initiatives where ship owners or companies who are complying with the international legal framework are awarded in terms of, for instance, lower prices for insurances, etc. So there are definitely incentives there going on, but I must also say that I'm not an expert in this, this private maritime law. In relation to your second question about whether there are mechanisms to incentivize retrieval, there absolutely is. The FAO is developing these initiatives, and I personally also see it as a very important part of mitigating the abandonment of gear that ends up at sea. One can also hear, it's important also to distinguish between the causes for the fishing gear ending up at sea. Sometimes it's completely accidental that you lose your fishing gear. For instance, there can be a storm, there can be strong currents, it can get snagged into the marine or the bottom or a species and then get hauled overboard. Then you also have maybe an incentive to try to retrieve it. Whereas in other cases, and quite commonly, there is IUU fishing taking place, and instead of facing the consequences when there is a potential risk of detection, it's easier for these vessels to actually just dump the gear overboard. There, the incentive then for actually trying to retrieve it is just not there. But I think in those cases where the cause of the gear loss is not intentional, then it's important to give these incentives. And that also applies in terms of bringing fishing gear back to shore. If you have a fishing gear that breaks during operations, it's much better to bring it back to shore and then dispose it through suitable gear disposal systems rather than just throwing it into the ocean. In terms of specific things, I have seen in debates regarding these regional fisheries management organizations that some of them are looking into whether they can establish such incentives for bringing back gear and also for actively retrieval of accidentally lost gear. So there are initiatives ongoing, I would certainly say, and they relate to whether one could think about models where vessels and states which do comply with these regulations, maybe, for example, have benefits in other areas of that RFMO. Let's say that it can affect quota allocation to a country, for example. So these are very interesting questions and ongoing discussions. Regarding your last question about enforcement and what a potentially global treaty can add to this picture, I think it's important to again stress the interconnectedness between ALDFG and other issues in fisheries such as IUU fishing. I think that we need to, no matter whether we get a new treaty which includes fishing gear or not, I think we need to enhance enforcement efforts in any case. and that is an important but also very difficult task to do. It comes down to strong flag state control, for example, to implement measures in domestic legislation which facilitates the actual implementation in practice. But I also think that the Plastics Treaty, or the negotiations for the Plastics Treaty, in general has also drawn more attention towards fishing gear, as it's been there and it's been also a debated issue during these negotiations. So in that sense, I do believe also that maybe, although we do not get necessarily the Plastics Treaty that we hope for, I still believe that the focus on fishing gear as a source of marine litter and plastic pollution may actually also enhance effective enforcement. Because if states can commit and we can develop the proper technologies and share the capacity in terms of monitoring, then I think the future will look brighter. I hope I answered your questions.
Greg, microphone, please.
Good afternoon. My name is Edmond from Kanda. I've lived for most part of my life near the beach, and currently, if you go to the newly constructed Jamestown Harbour, the landing beach near it, half of the beach is filled with plastic. My question goes to Prof. Mahu. I don't know if she will recommend as part of the measures to curb the menace of plastic menace, to ban the use of plastic altogether and replace them with recyclable. Thank you.
I'm George from King's University, and my question, before anything, I'd want to commend the last speaker on her exposition. It was really good, and it got me convicted in a way to be an agent of change, because I feel the information she shared in her research, it's something to be amplified to the general public, and that leads me to my question. I want to know if it is possible to collaborate with stakeholders in the media, in education, and NGOs to amplify and promulgate your research to the general public, because awareness, as you mentioned as one of your remedies, is key in solving or tackling the problem. Thank you.
Thank you very much. Please, my name is Gabriel de Graft, a student of maritime law. I'm a maritime law student. My research area is actually on blue economy. So my question is actually to Professor Mehu. I was once your student in 2003, so 2023, sorry. Please, I would like to know, you see, when we were mentioning the plastic things, we have been able to done it so well that now people pick their plastics and then they are even now selling it. So there's a market for it now. My question is, what happens to, because when you mentioned also in the presentation of the second-hand clothes now, you realize that most of them that they are great. They are ones that when you go to the Cantonmanto now, you see most of them on the floor, then they end up at the beach as well. So I want to find out what measures are we also taking on these ones, because it's also affecting us in that regard. So since now there's a way we are dealing with the plastics, what happens to these second-hand goods and others that also end up in our beaches as well? Thank you very much.
Hello everyone, my name is Samuel Alesudoji. My question goes to Ingrid. In your final slide, you touched on lack of collaboration and also fragmentation as part of the challenges in resolving this particular problem. within the context of international environmental law, fragmentation is actually a very big problem because we have different legislation, different treaties dealing with problems which are in a way interconnected. As part of your reflections, are there workarounds that you can suggest in terms of addressing and minimizing the potential, gaps in enforcement arising out of having a fragmented international treaty arrangement?
Okay, thank you. Thank you very much. My name is Godwin Jokoto, and I'm a senior lecturer in this school. So I have a number of questions to be directed at the panelists, and I'll start with Professor Aleke O'Brien. And the first has to do with what are the contentious issues in the negotiation of the Plastic Convention. I want to know what the contentious issues are, the reasons for which they are not able to reach an agreement. And I would also like to know from her what are the various divides between the developing nations and the developed nations in relation to plastic pollution. And also to find out from her if there is hope for the conclusion of a treaty in this direction. Then a question directed at my good friend, Professor Mahu, is what are our options? You are saying that the next time we organize this conference, we shouldn't bring these plastic bottles. What are our options? So if you can please help us in this. And it's just not limited to the storage or the holding of water, but generally, what are our options? Then I also want you to please throw light on plastic inhalation. How does it happen, and what are the consequences? And also, if you can please help us with the technology for cleaning plastics from our marine environment. Then my last question goes to Ingrid, which is a question close to what Sam asked, and has to do with why do we need a convention which would deal with fishing gear? And I would have thought that a general convention relating to plastics would be good enough to deal with all these matters. Thank you.
Okay, so I will start by addressing the two questions, which I think are really interesting questions indeed, because when we're thinking about fragmentation and environmental law, we see that we have the same also in, for instance, pollution law, fisheries law, and it's just something that is there. Potential solutions to address this, this fragmentation and also to enhance enforcement, I think that's it's a tricky question to answer per se, but I do believe that if we have, let's say, a global instrument recognizing, for example, ALDFG, abandoned, lost, or otherwise discarded fishing gear, I think that may enhance the commitment by states to actually maybe try to do something about it, and that it may provide a common arena for states to actually discuss and try to find solutions altogether. That being said, and this relates to Professor Goodwin's question as well, when I was preparing for this presentation and reading up on the latest literature, it also occurred to me that we actually have a lot of framework, legal framework already. So do we really need yet another instrument when the issue clearly lies in the actual implementation of these obligations? And how would then a plastic treaty add on to the already existing framework? And these are really important questions to address, because obviously we have legally binding obligations, a lot of them stemming from, for example, MARPOL, Annex 5, which has almost global coverage, and yet we are failing to implement it in practice. And that's not something that adopting a new instrument by itself will solve, because the problem is still there. But my hope for the future is that maybe we will see a more coordinated action, have yet another forum for actually discussing and finding the right solutions for the future. And in that sense, I do believe that fishing gear, or that it's important to also include fishing gear in the plastics treaty. But really good questions. Thank you.
Okay, so to the very first question, would I recommend that we ban plastics altogether? I think that banning plastic altogether may not be possible at this point. We need to start from somewhere. Which plastics are the problem? That's where we need to start from. And I have been to the Jamestown fishing harbor myself. The last time I went there, I felt so ashamed. What are the commonest plastics that we see there? We see this kind of things, the single-use plastics. They are one of the problematic plastics. If we want to ban plastic, then what about the wheels under our cars? You know, some of these plastics have become very essential, but there are some plastics that we can actually do without. And these are the single-use plastics. And these are the ones that we should be banning. There should be an outright ban on the use of single-use plastics, from PET bottles to the polyethylene bags that we take when we go to the supermarkets. We should replace those ones with the tote bags, to the sachet water that we've been drinking. These are all things that can be banned. But then again, I'm a scientist. I can only advocate for that. But these are the ones that I think should be banned outrightly. Whether it's possible to collaborate with non-scientists to communicate the findings of our research, that is very, very laudable and welcome. Scientists, we are always interested in putting our work in peer-reviewed publications, because that's where we get the promotion for. But a lot of the work that we do should be put in the public domain. And so, for me, I've done a lot of, I've granted a lot of interviews on microplastics, not only locally, but also internationally, in close connection with the second-hand clothing that I talked about, because you realize that that is not really a national problem. It's not a problem that is nationally originated. It's coming from somewhere. And so there's a lot of interest from the north, where we are getting this clothing from. There are a lot of NGOs there who are concerned about the problem, alarmed about it, and they want to do something about it. So when they come to my lab. So yes, my data is available. If any NGO wants to come for our data and use for sensitization, please feel free to contact us. Then the question on what happens to the low-grade second-hand clothes. What do we do if we are now trying to recycle plastics? What should we be doing with these ones? This question boils down to capacity. This is a problem that we have just started recognizing as an environmental crisis in Ghana here, and also globally. And so we need to develop the capacity locally to be able to recycle these second-hand, low-grade second-hand clothes. But even with the plastics that have been with us for all this while, we haven't been able to develop the capacity fully to be able to tackle the plastic. So why do we even want to add on to that? So for me, my proposal and the way the campaign is going is that fast fashion, we all know, is a major contributor. It's very cheap to produce clothes with polyester than to produce clothes with cotton. Cotton is biodegradable. The last interview I granted was with a German NGO. And what they are doing is to push brands, big brands in Germany, to phase out the use of polyester in their production line and use cotton. That is what they have been trying to advocate for. What we have on our beaches now, we have an NGO, the All Foundation, who is trying to, recycle some of these clothes and, convert them into something else. But at the end of the day, it's still polyester. So if you recycle and somebody goes to get it, to model it, or to use, what is the life cycle of that recycled cloth? So the problem will be to tackle it at source. Whatever legislation that is allowing the importation of the second-hand clothing into our country, we need to look at that closely. It's not every cloth that is worth being shipped over to Ghana. That is how we have to see this problem. What options or alternatives are there for, plastics? Yes, there are a lot of alternatives, especially for the single-use plastics. When we all go to the supermarkets, you see that sometimes they can put one item in about 3 polyethylene bags. That is where you have to tell the person that I don't need all this. We can carry the tote bags with us. Historically, we all know, we are all not too young in this room. We know that when we were even going to the market, we were using baskets to go and shop. So what stops us from doing that now? Buying your tomatoes, onions, and everything, they put in the bucket, and then you come home and come and sort. These days, we all enjoy lazy life, so we want everything to be bagged, and then we come home, and it's so easy. We think it's very easy, but it's coming at a cost to the environment. We should also use the water dispensers. At least, if you have a bottle, one big water dispenser, at least you can reuse it over and over and over. And that one is also one that those who are picking the plastics are always looking for. Even people want to store water in it. So we should, in a way, minimize the consumption rates. There are a lot of alternatives. These days, I just saw that Ghana is banning the styrofoam boxes, the takeaway packs, which is very laudable. Let's eat in bowls. So there are a lot of things that we can do. There are a lot of alternatives. It's just that we think that the plastics have become so convenient for us, so it's difficult to stop using it. Yes, plastic inhalation. Mostly this is microfiber, the very lightest of the plastics. And they are all over. They are, like I said, our clothes are shedding them off. Fishing gears are shedding them off. In the industries where microplastics are being produced, for example, where they are producing these polyethylene bags and all that, in the process, they shed out a lot of these light plastics, and that is how come we are breathing them in. They are in the air. In our research, when we are doing the microplastic analysis, we do what we call the blank. So we just put a filter in the lab, and then just allow plastics that is in the lab to settle. And you will see that with time, there's some amount of microfiber that has settled on the filter paper that you have put there. So they are all around us. Then in terms of the plastic technology, yes, I talked about the coral ball, but there are, if you review the literature, there are a number of other technologies that the tech-savvy people are coming up with. A lot of it also integrates science, because you need to understand what the plastic is, what technology can actually absorb or attract the plastic, and then you come up with a technology. So there are a number of technologies in the pipeline, but the one that I have seen and tried is the coral ball that you put in the laundry basket, and it's just spins, just like you are washing. So it's like a comb. So as you are washing, but it doesn't shed off your clothes. It's very smooth and nice. So as you are washing, the machine is spinning, it's also spinning, and any fiber that is being shedded, it's just, collecting it, and then at the end, you just take it out, and you can send it to the manufacturer, and then she will do what she wants to do with it. She's in the US. She's my very good friend, too. So, yeah, I hope I've answered all the questions. Thank you.
Thank you, Prof. Mahu. Prof. Aleke, please, are you still with us?
Yes, I am.
Wonderful.
Thank you so much. I've learned so much about science as well. So this is even more case to have this plastic treaty, including a standalone article on health, which a lot of people have advocated for. Thank you so much for the questions on the contentious issues and the divides. I didn't really And whatever goes beyond that, you're punished for that. You have to pay for that, and then you have quotas and education rights. So I think this is something that's very contentious. A lot of countries would like to see that, but other countries say that a production cap would limit and impact the sovereignty and sovereign rights of countries to use their resources. And it is I'm not saying any secrets, because it's Chatham House rules, of course, at the negotiations, that the petrochemical states have a very strong interest of not capping plastic production. And they said that we should continue producing plastics and then push it towards the circular economy for reuse and recycle, but that we can just continue producing. So these are the really big items. One is the life cycle production caps, and then including also chemical and climate change aspects, and then if we have enough evidence to address things, and where is the money coming from? So linking substantive obligations with that of financing. These are the big issues, and the divides are interestingly not so much about developing and developed country. It is there are two major groups beyond the normal UN groups and negotiations. And these are the High Ambition Coalition, and Ghana has played a very active role in this regard. And the High Ambition Coalition is, I just checked, 94 countries, including the European Union, that have a very strong idea that they want to have a cap on plastic production. They want to have a standalone article on health. They would like to have a very strong finance mechanism that is not voluntary, but that is obligatory to have a core budget in it. They want to have mandatory global responses and not so much the national voluntary responses that's advocated for by other groups. And then what is also quite central is that the idea of a compliance mechanism that some countries are against, but we know from other conventions, including the UN Convention on Biological Diversity, I worked there, the national reporting that was used to understand where countries stand was quite difficult in the implementation because a lot of countries didn't really report on this one. So if we could overcome the fragmentation in international law and have a adhere to like a common procedure for reporting, for example, to understand what are the gaps, what are the problems, that would help a lot. And to actually link the reporting to financial support and capacity building, that would be of absolute importance, in my opinion, to support all countries and in the world to reach the goals of having, in the end, less plastic pollution and to meet the obligations under the treaty. The other group that's very distinctively, and I would like to put it out there, is so-called the Coalition of the Willing. And these are countries, it's a little bit of a dynamic group, but it's petrochemical states. So it would be Saudi Arabia, Qatar, United Arab Emirates, sometimes Iran, it aligns with them, Iraq, China, Russia. So sometimes they are identifying as such, and sometimes they are just speaking for themselves. But this is a very interesting group that has targeted very much the idea of waste management treaty, voluntary measures, no global responses, and national measures. So these two juxtapositions, group of countries are in place. And I think, interestingly enough, I would not say that the divide between developing and developed countries is that strong, except for the financial mechanisms. We see patterns similar to climate change as well, where there's a strong urge for substantive targets, but maybe the commitment to financial mechanism behind this is not that strong. But overall, this treaty process has not been so divisive in this regard, because the evidence is very strong. I do hope. Oh, and if I have hope, then that's the only way. I've got children. I know how women and children particularly are very much affected or more affected by the chemicals and with the toxicity in the plastic. So there's no way that we can stop at this point. I don't want to give up hope, and there is already a proposition to have an INC 5.3, so it's a third meeting, but that will go to the United Nations Environmental Assembly, and the current draft includes a proposition for that one. I don't want to have a INC 5.14, I don't know, in 4 years, 5 years, that we just continue. There needs to be an end date. And if this fails, then we need to strengthen our sectoral work, like what Ingrid, for example, mentioned, on fisheries with the International Maritime Organization, World Health Organization. So this is a really important time in our life not to lose hope. And yes, otherwise we have done so much for nothing. So thank you.
Thank you very much, Prof. Aleke. We are able to take about 2 or so questions. Okay. Exactly 2 hands, perfect. Okay. Okay, the hands keep going up.
Thank you. My name is Abu. I'm from the BAM Library.
Please be as succinct as possible.
That would ensure that ocean issues are highly considered as a national political agenda that goes beyond election cycle, so we can tackle this once and for all. We want to know what is the mechanism that we are going to put in place from here, so that this will be considered as a national agenda to be discussed. So if there's anything to do, we do now, then we can be safe.
I'm Mamikwa from the University of Ghana, and research indicates that in 2016, a bacterium able to degrade plastics was discovered. So my question is, can plastic-eating bacteria offer a viable solution to the problem of oceanic waste? Has there been research done on this?
All right, thank you very much. My name is Ohini Janadai Bonsu from Lesiad. My question is to Prof. You mentioned the use of baskets, for example, for shopping. Now, you're coming from academia. It seems to me that sophistication and modernity is what is bringing us these disasters. Is there any way you're advocating for us to go, let's say, back to the future, where we can use a lot of biodegradable material, for example, in our homes? When I was growing up, there was a lot of things that were biodegradable. But now we say we're more civilized and more modern, and yet what we're using is killing us. So from your standpoint, is there anything that you're doing for advocacy for things that are biodegradable? And then I wanted to ask, I saw and I've seen over the 3 days that we've tried to bring diplomats and people in government over, but it's obvious and it's evident to me that this cannot be done by academia alone. Without policymakers having the political will to do something about this, we can do all our researches, we can come up with the fine ideas, it won't be shelved. Because no company really gets up in the morning, no board sits and thinks about what are we going to save the sea. They're thinking about profit. This is what capitalism brings. So what are we doing, say, in organizing conferences like this, to really bring in the policy makers, the people who can call the shots, for them to appreciate that very soon we will all die because of the things that we're doing. Thank you very much.
Hi, my name is Paulina. I'm a rapporteur from Merton Everett. And I wanted to ask about the plastics treaty that was just convened about 2 weeks ago.
Paulina, could you speak up a bit?
Yeah, sorry. I wanted to ask about the plastics treaty that was convened about 2 weeks ago, the meeting to discuss and negotiate on the plastics treaty in Geneva. And essentially, it didn't get anywhere. There was a lot of back and forth, a lot of issues and problems raised by various nations. And I'd like to know what your thoughts are for Africa, and what will be required for Africa to think of a regime to govern its own plastic use and management, and not have to wait for the rest of the world to get on board and agree on something.
Okay, Prof. Aleke, please, are you still with us?
Yes.
Yes, if you could take the last one.
Okay, that is a difficult one because I don't want to speak on behalf of a region that I don't come from. But what I can give you as a feedback is that Africa, the African group has been incredibly strong, very resourceful, provided rapporteurs, and had a very clear vision and clear idea what they would like to get out of this. So, in my opinion, if there would be no ways forward with the plastic treaty, the African countries need to find, in whatever form, a regional approach, either through sectoral cooperation, fisheries, shipping, and things like that, or, and this is also being discussed right now as an alternative, go outside the UN system and agree on obligations there, and the Montreal Protocol is a case in point, and then once it has been established and effective, move forward. So I think that in terms of the knowledge and the capacity and the will to do something, this is such a strong group of countries. So this I would like to raise before, and unfortunately at the moment, and I would like to go back to Kofi Annan's quote: "Humanity is indivisible. We are one." So there needs to be some support. If say Africa would go on their own as an own individual regional team, and we have that, for example, in the European Union, that will only solve half of the puzzle, because we need to have a comprehensive global effort to address plastic pollution, because it's transboundary, because it gets suspended up in the air, because it affects us so deeply. Let's hope that there is no need to go on to regional agreements that might be very different and very fragmented and actually adding much more to fragmentation. And if there is a need, then I think there will be a very strong point in going the route of sectoral cooperation, but that will also have its challenges. So yeah, I would like to close here because I do not come from the African continent, but I do understand that you have very strong thinkers and visionaries actually. You have been really spearheading this entire process. So don't give up hope. And the entire world is together in this plastic treaty. So yeah, I'd like to finish again with the finger pointing to hope.
Thank you. Prof. Mahu.
Okay, all right. So the first one was, how can ocean issues become a national agenda? That's a big one. Yes, so one, we need to start from somewhere. I believe that for a lot of us in this room, had it not been for this week, this conference, we are not even aware of the challenges that confront the coastal ocean environment. And so awareness creation is key to this process. We have a few scientists in this country. Oceanography is, unfortunately, is a small component of the science that we are doing in this country, even though our EEZ is almost the same size as our land. We have not invested so much in understanding the ocean as a country. However, thankfully, we still have some resilient scientists in this country who have done so much work to bring out the core issues. But a lot of this is also resting in our libraries. We are only interested in publishing the work that we are doing without bringing it into the public domain. And so we need to make that effort as scientists, that the work that we are doing, because we understand the problem, we know what is happening. There are a lot of things that if you don't analyze the water, the chemistry, you will never know, apart from just the plastics that you see around. But there are so many issues that if you don't do some scientific work, you will not know. So when we do this research, we should find a way to bring it to the public domain. We need to bridge the science and policy gap. We all know that there's a big gap here. When we do our research, we need to be able to take the work that we have done to our policy makers. And these days, what is even being advocated for is that you don't wait till you finish doing the research before you carry it and go and give to the policymaker. Co-design the project with the policymaker. Start with the policymaker. Start with the communities, those that need to take action. Start designing the project with them. So by the time you are done implementing the project, they have a very good understanding of what the problem is, and they co-own the outcome, the findings of the work. That way it's easier for them to what? Act. So we need to be doing this co-design projects. There was a question on plastic-eating bacteria. Yes, that is very, very true. There's research that has shown that we have some bacteria that can actually degrade plastics. The research is currently ongoing. We call this one bioremediation, where biological organisms can help to clean up the system. It's a very, very slow process. It involves isolating those bacteria, bringing them to the lab, culturing them, and then introducing them to plastics, which can take quite a bit of time. It's very slow, but it's also one of those remediation processes that we have, that is recommended. I don't know of anyone in Ghana who is looking into that. So there are still a lot of opportunities out there for our students, our PhD students who want to go into that. We have a lot of molecular labs in this university that we can, that can do that sort of work. So that can be taken up. What are we doing to bring policymakers to understand the nature of the problem that we are talking about? I think I talked about that already. We haven't done so much as scientists. We focus so much on promoting our career. We need to work hand in hand with our policymakers. When we come out with the findings of our research, we should think of our policymakers as the first point of even sharing the data that we are collecting. Instead of, when we find new data, we are always thinking about publishing first. But we need to think about our policymakers. Our data should help inform policy. And like I said, we need to co-design our work with them. Is there anything that, I think the question was, I am doing for advocacy for biodegradable alternatives to plastics? Personally, I am not involved in any of such advocacy. I do more of the science, but I also partner strongly with organizations like Plastic Punch. Plastic Punch has become very popular in Ghana now. They were collecting plastics, and they are, I think, the first organization that started reporting to SDG 14 on marine litter. Now they've moved from just collecting data to researching biodegradable options and also promoting the use of these biodegradable options. I've worked with them quite a lot, but I think that we can have more of this Plastic Punch. And the alternatives are not things that are very far away from us. They are in our backyards. We can fall on those alternatives and use them in substitutes for the plastics that, or the single-use plastics that we've all become very used to. I think that's all that I have here. Thank you.
Thank you very much. Very last question. Then we bring the session to a close.
My name is Angela Kwe, UG and Judicial Service. Mine is a suggestion. So I want to suggest that we create an awareness to the public. We just reach the communities, educate them about plastic waste management. We have to look about that. Because last year we were here to discuss the same issue. Today we are here. We are discussing the same issue. But you and I will have the insight. What about the community? What about the market women, the traders? So we have to reach them, gather them, group them, put them together, educate them how to use it. We can even start to use this strategy that we have in communications that we call two-step flow. So I will tell you, you tell the other party or the other friend how to use the plastic waste. And I think it will also reduce all these issues that we are discussing here today. Thank you.
Thank you so much, Prof. and Ingrid and Prof. Mine comes in as a call to action. Just as my dear sister mentioned, last year we were here, we spoke about the same thing. Ladies and gentlemen, this is plastic. Okay? It's plastic. I think in talking about the alternatives, I'm pretty sure that we have, paper bags and, what have you, that these takeaways, of course, can even be put in. Many years ago, before these takeaways became so rampant, we used to use the leaves for our food. How many of us remember in our local communities? You go and buy your wache and you request for your leaf and all that. It came and some people said, we call some the positive domestication or some, when they were trying to in a very fancy way, in a subtle way, before you realize it became, you are seen as, let's say, a rich person or a popular person or some person of importance if you are using the takeaway or the foil. Even the takeaway has even migrated to foil. If somebody buys food and use takeaway, I want the foil, that's seen as the ish. You're in the university, so we see it. A call to action. From today, as we live here, with all the things that we have heard, let's start using or going back to the alternatives. Using the paper bags, using the leaves when you go and order a popular wache. And trust me, we'll reduce these plastic pollution to the barest minimum. Thank you.
Thank you so much. Your contribution only goes to show how important this subject is to all of us.
Hello. Yeah. Sorry, just to complement a little bit what Prof said and what he said. So with what he said, I think science communication, we need to have scientists that can also communicate. Because with what he said, I think the big issue is also with branding. From my casual knowledge, one of the things that we did was to kill Azonto, because we started branding it as something for choco people. So, that died down. So we need to have people that will start looking at the creative ways of communicating some of these initiatives or alternatives, local ones, promoting the local knowledge. And with regards to what someone asked about bringing the policymakers, I think that question wasn't duly answered, in the sense that I was expecting them to also talk about this conference particularly, if they have brought the policymakers, and how much of the policymakers have they brought, what is their engagement, so that they take away something, so I think maybe everyone's frustration is that every year we have the same conference, but nothing is really changing. And the government a little bit is working on the Blue Economy Commission right now. Yesterday I was at the technical committee meeting to the strategy, something like that. So there's a lot of work going on the knowledge, so I'm pretty sure that Prof. Adam and many people here are aware there's a lot of technical work going on to improve how policy can actually, focus on the ocean. So work is going on, and I think we can try to get updated with what work is going on and how we can contribute to the work going on as well. Thank you.
Thank you very much. Our time is up, unfortunately, but afterwards you can have a discussion with Prof. Mahu and the team. My apologies, our time is up. This afternoon we've had the importance of this subject has led to the development or the process of developing a global legal regime for marine plastics. which we had expertly delivered by Prof. Aleke. And then we had a presentation from Dr. Andreasen on marine plastics and fishing gear, for us to understand that leaving our fishing gear in the ocean also has its negative impacts. And the one, Prof. Mahu's presentation on microplastics, which has led to a lot of discussion, because we see that it's on our plates. But let's bear in mind, I mean, people are talking about, we do this every year, but what is changing? We do this every year, researchers and panelists come here, we speak, but you're also here. You're also meant to pass on the information, because really, we can't fit everybody in this space. So you are also representatives of your institutions, you are representatives of your families. So what you find out here, the expectation is that you pass it on to others. That way, the information is going out there. Bear in mind that it's a collective responsibility. So we have a responsibility to our environment. I expect that everybody will take their bottle out and dispose of it properly when we leave. Thank you so much for your time. The next thing is the closing ceremony.
All right, thank you very much. And thank you very much to Dr. Winisowa for moderating the last session. We are extremely grateful. And we thank all the panelists for your great contributions this afternoon. We've learned a lot. I really enjoyed this session, just like the other sessions. And it tells us that, yes, law alone is not enough, and that we need a collaboration with other sectors to be able to contextualize. We are extremely grateful to you all. So all too soon, the second international conference on ocean governance, organized by the Ocean Governance Research and Development Project, has come to an end. And we are extremely grateful to God for a successful conference. Now, as you know, the theme for this year's conference has been emerging issues in the marine environment and the law of the sea. And this conference started from the 2nd and is ending this afternoon. We started with a welcome address from the Dean, as well as from the Pro-Vice Chancellor, Professor Gordon Awandari, in welcoming us and setting the agenda in terms of the marine and ocean strategy for the university. We had a special guest address by the Honorable Dominic Ayine, Attorney General and Minister of Justice of the Republic of Ghana, who was ably represented by the Solicitor General of the Republic. We also had a director from the Ministry of Environment, Science and Technology, representing the acting minister for the Ministry of Environment, Science and Technology. We are privileged to have a solidarity address read by Her Excellency Ingrid Solas, who is the Deputy Head of Mission and Minister Counselor at the Royal Norwegian Embassy. Then we are really privileged to have a keynote address rendered by Judge Osman K. Kamara, a sitting judge of the International Tribunal for the Law of the Sea. And he spoke to us on the subject of the significance of the advisory opinion of the International Tribunal of the Law of the Sea in relation to climate change. Then we started with the panel discussions. We had 5 panel discussions in all. We started with the first one, which was on the theme, climate change and its impact on the marine environment. Legal, policy, scientific, and social responses. We had the CEO of the Environmental Protection Agency and a member of the Intergovernmental Panel on Climate Change, Professor Nana Ama Brancluche, deliver the keynote address on the theme. This was followed by a presentation by Dr. Peter Derry, who is a director at the Ministry of Environment, Science and Technology. He examined the legal frameworks governing climate change, mitigation, and adaptation measures in the marine environment. Professor Simon Bawachilenu from ISA analyzed the socioeconomic impacts of climate change on marine ecosystems and coastal communities. Dr. Kwame Ejekum, in characteristic fashion, once again explored the scientific advancements and technological solutions to mitigate the impact of climate change on the oceans. We're privileged to have Professor Dr. Bima N. Patel, a member of the United Nations International Law Commission, to deal with the subject of regional cooperation in the Indian Ocean region for the protection of the marine environment, considering the legal dimensions. Our good friend, Mr. Samuel Alesudoji, dealt with the issue of Galamsey, and he spoke on the topic, illegal mining and the Ghanaian state's responsibility to protect and preserve the marine environment. On the second day, we had 2 sessions, one in the morning and the other in the afternoon. The one in the morning had the theme, Marine Resource Management in West Africa, Legal Frameworks and Policy Challenges. We had the first speaker being Dr. Sylvia Dusu, who is a director at the International Law Division of the Attorney General's Department, and she examined the role of advisory opinions on climate change, the impact on marine resource management. Mr. Kofi Agboga gave us a wonderful presentation on examining the role of community involvement and traditional ecological knowledge in marine conservation. We had Paulo Henrique de Oliveira, who spoke on shipping and its connection with the marine environment. The topic was, can the shipping industry be an ally in environmental protection? The role of charter party contracts in marine governance. Then we had a collaboration of 2 lecturers, Professor Wazia Po, who is the Dean of the University of Ghana School of Arts, and Dr. Samuel Amate from the Department of Archaeology and Heritage Studies. They spoke on the topic, Integrated and Sustainable Blue Economy, Contributions and Challenges of Underwater Cultural Heritage. Then we had a good dose of mercury here with Dr. Leila Gifti-Akita, and she spoke on the special assessment of mercury levels in the Volta estuary, an environmental health perspective for pollution policy reforms. Then in the afternoon, we had another session which was themed Sustainable Fisheries Management in West Africa, Balancing Economic Development and Environmental Protection. We had a keynote address rendered by Professor F.K.E. Nunu. Then we had our friend Che Yamwa speaking on managing impacts on fishing livelihoods arising from climate change and fisheries law enforcement. Professor Sam Ado from Marine and Fisheries Sciences spoke on enhancing growth in mariculture for fish food security. Our good friend, Sir Emmanuel K. Klubi, spoke on seaward evaluation of the effectiveness of defense structures along the beachfront communities of Ghana. And the day ended with a presentation by Mr. Stephanie Shandorf, and she spoke on understanding the social and cultural implications of legal frameworks for fisheries governance in West Africa. This morning, we're privileged to have a session themed Beyond the Text, addressing implementation challenges of the BBNJ agreement in Africa. The keynote speaker was Professor Maria Madalena Das Neves from the Faculty of Law of the Arctic University from Tromsø, and she spoke on Beyond the Text, addressing implementation challenges of the BBNJ agreement in Africa. Then we also had Mrs. Kalila Hackman, who is the Deputy Director, Legal and Treaties at the Ministry of Foreign Affairs, speaking on negotiating marine environment treaties, lessons from negotiating the BBNJ process. Ms. Peace Beko-Kove, who is Director at the EPA, spoke on overcoming fisheries management barriers for biodiversity protection under the BBNJ. Our good friend from Argentina, Dr. Alejandro Sebastián Canio, spoke on Behind the Text, addressing the implementation challenges of the BBNJ agreement in Africa. And the morning session was concluded by Harun O-Rashid, and he spoke on opportunities and challenges in implementing the BBNJ agreement, a perspective from Bangladesh. And a while ago, we concluded the last, but not the least session, which was themed Developing a Global Legal Regime for Marine Plastics, Reflections and the Way Forward. The keynote speaker was Professor Aleke Stephen O'Brien from the World Maritime University and the IMO. She spoke on developing a global legal regime for marine plastics, reflections and the way forward. Then we had our own friend from the Norwegian Center for the Law of the Sea, Dr. Ingrid Andersen, dealing with the subject of marine plastics and fishing gear. And the marathon was ended, or the relay, by Professor Edem Mahum, who dealt with microplastics in the marine environment. At least she succeeded in telling us that we have all been eating microplastics. I'm sure this message is well ingrained and we cannot forget. So this is just a total wrap of all that has happened so far. Now, many legal, policy, scientific and technological challenges affecting the marine environment have been well analyzed, and many solutions have been prescribed. And we will do very well in the post-conference documents to detail this out, which we shall share with the relevant institutions as our joint contribution to the international and national dialogue on issues affecting the marine environment. And we will also do very well to publish a copy of the report on our website. At this juncture, it's my singular pleasure to say big thanks to our sponsors, the sponsors of the Ocean Governance Project, as well as this conference, meaning the Norwegian Agency for Development Cooperation, NORAD, as well as the Norwegian government. We are also extremely grateful to our friends from the Norwegian Center for the Law of the Sea at the Arctic University in Tromsø, Norway, who are ably represented here by Professor Maria, Professor Ingrid, as well as Lady Christine. And we say we are truly grateful for taking the trouble to join us here this time. We're also very grateful to the Office of the Vice Chancellor, the Vice Chancellor, the Pro-Vice Chancellor, the registrars, the provosts, the coordinators, the moderators, and the speakers, as well as all participants, and the various conference teams. We had the IT and all the other teams composed for the purpose of efficiently running this conference. We say we are truly grateful, and we say, Ayeko. Thank you very much. At this point, I would invite Professor Maria Levis to say some few words before we hand over to Provost.
Thank you, Goodwin. Just to share in the sentiments that you have expressed, but to say that we have had 3 intensive days of very fruitful and thoughtful discussions. And we have noticed that we have many challenges when it comes to protecting the marine environment, and that none of these challenges are of easy solution. It will take time, resources, goodwill, capacity, and this is an effort in which we all take part. We all have a role to play. And as Professor Winnie was saying, when we leave this room, it's about sharing this message, taking this forward, taking to the authorities, but other stakeholders, general population, our students, our families, and I think we have learned quite a lot from one another. Some people might say that the Arctic and Ghana are worlds apart, but we share some of these same challenges, and it's good for us to share different perspectives. So I, for one, and I'm sure that my colleagues will go back to Norway, far richer for having had the opportunity to share these days with you. We will definitely be recounting this to our colleagues and to NORAD and the Norwegian authorities to also facilitate the continuance of this project. And in this sense, I also share Goodwin's thanks to the Norwegian Development Agency for Cooperation that facilitates this project, but also the University of Ghana and the Faculty of Law of Ghana, as well as our own domestic institutions. Because they have truly facilitated this, and especially every time we have been in Ghana, always welcomed us with open arms. We feel almost at home here. We want some more days to feel the full Ghana experience, but we would like really to show you our gratitudes. And also, these conferences, we are co-organizing, but I love when I co-organize a conference and I just show up and everything has been prepared. So I understand there has been a large team that has put this together, from logistics, invitations, food, etc. So the success of this conference is also very much due to them and to the leadership of the faculty and the Ocean Governance Center. So thank you very much.
Thank you very much. Now we would invite the Provost of the College of Humanities, who is in the person of Professor Joseph Awetori Yaro, to deliver the closing address. Just by way of brief introduction, he is a human geographer with a research focus on rural development. And by way of education, he blends Ghanaian education with Norwegian education very well. He obtained his BA Geography and Resource Development from the University of Ghana, an MPhil in Development Geography from the University of Oslo in Norway, and a PhD in Human Geography also from the University of Oslo in Norway. By way of research interests, it includes climate change adaptation and resilience. And he currently has not less than 18 research topics and projects underway, including some on the ocean, as well as others on sustainability in the marine sector. Ladies and gentlemen, please put your hands together for Professor Joseph Awetori Yaro to deliver the closing address.
Thank you very much. And thanks to all of you for sitting here for the past 3 days on my behalf, since we have been walking around. So distinguished guests, members of the diplomatic corps, I'm sure we still have representatives of ministers and ministries present here, our friends from Norway, delegates and friends of the School of Law, University of Ghana, ladies and gentlemen, good afternoon and evening at the same time. So it's a privilege to come at the end of a well-celebrated conference. As you saw, the MC struggled to summarize the very wonderful and rich deliberations that have been going on here. And the wonderful organization is summarized in the words of my friend from the Arctic, who says that everything just was perfect. So there was no need to scratch their heads, you know. You're not the only people who scratch their heads on earth. In Norway, they scratch their heads a lot under difficult circumstances. So as you heard over the past few days, there has been immense and critical discussions which transcended several disciplines, geographies and world views. We have our canoe worldview here versus the huge icebreaker worldview, and of course also their historical worldview of course invading Europe from the top. All that is part of the ocean governance today in a historical perspective. As MC mentioned, though our projects have involved, and we won't call them oceans, but we have grappled with issues of fish that comes from the oceans. And one of the rules that we have not been happy with is rules about the size of fish. And that is what our 4-year project looked at. Small fish. Small fish that is hated by every regulator. Fisheries Commission, you are here. You don't like our canoe guys getting small fish. I support them. We need to catch the small fish because we have to fish, we have to feed the poor. The rich, you need 20 fishes to get 1 meal. The poor need only 3 fingerlings. So please allow them. So as you know, College of Humanities, under which you have law, is very proud because the School of Law has actually played its role in this project very well. And this, as we met the ambassador here, when was that? Not long ago, isn't it? And they were all very pleased at the way this project has run and the outputs that has been achieved. So therefore, the academic leadership on display this week obviously reinforces our belief that interdisciplinary research is not a luxury, it is an imperative. It is through such collaborations that we can reimagine governance systems, deconstruct inherited hierarchies, and build locally grounded, globally relevant knowledge frameworks. And let me acknowledge the strong support of our international partners, as already mentioned by the 2 speakers before me, NORAD and the Norwegian Center for the Law of the Sea. Without funding, wonderful research, great knowledge can never be produced. So we are very grateful to these 2 who are also funded by the Norwegian government. And certainly this long-term collaboration with our university has and will sustain academic activity in this space and will foster a growing community of scholars, practitioners, and advocates committed to shaping ocean governance from the continent outward. And I'm happy to see, different people in uniform. I'm sure that's the Navy, some dignitaries in coats. When you see people in coats, they are from ministries, very powerful. They can create. Once they understand the kind of knowledge we are producing, we are sure that the governance of the oceans and the laws that we create are going to be favorable for a better world. So based on all the wonderful contributions by the funders, by our researchers, I will also still want to respectively call on NORAD to consider supporting the establishment of the center through a dedicated seed fund, a center that we can have here that would move from idea to institution, which will be equipped with resource and recognized as a hub for knowledge production, policy engagement, student training across West Africa and beyond. And we hope that NORAD will consider putting in a seed fund that will move this laudable initiative forward. In the same spirit, I also want to issue a call to action, not only to our partners, but to ourselves. Let us move swiftly to embed this work into our curricula, our graduate programs, and our research funding priorities. So let's support our early career researchers, doctoral students, faculty who seek to make lasting impact in this field. Now, there is also a broader imperative here. Ghana must not only participate in global ocean governance conversations, but must also help shape them. We must assert the knowledge systems, legal traditions, and ecological priorities of our region and nation with confidence, because it will be scientifically grounded with facts. This conference, of course, has shown that we are ready. What comes next must be about institution building, capacity strengthening, and strategic persistence. To all the participants here today, I hope you depart with new insights, renewed connections, and a deepened sense of purpose. May the ideas born here spark further research, new collaborations, and more inclusive forms of advocacy and policy making. And I will also add to the young PhD students new topics. You will abandon some topics and move on to these groundbreaking thoughts that have been expressed here. And to the organizers and the volunteers, your tireless work behind the scenes has not gone unnoticed. From logistics to programming, from student volunteers to academic leads, you have given us a model of what excellence in convening looks like. We are deeply grateful. And I'm grateful to the project owners for bringing young people, for getting young people involved. This is a huge opportunity that we were excited about when we were students. It's very important that we get involved. We learn things from that and we grow up. So may the waters we seek to govern be sustained by the knowledge we continue to produce, and may the University of Ghana remain a beacon in that journey. Thank you very much, and safe journey to our colleagues from far, far away.
Thank you very much, Prof. Yaro, for that inspiring message. So, all too soon, we've brought the program and the conference to an end, and we will rise, take the University of Ghana anthem, and when we are done, we'll take photographs to be in 2 sessions, the high table, and then we will take one global picture, and that will be the end of it. So if the IT guys are ready, please help us put up the words of the University of Ghana anthem and have it rendered. Please, let's rise.
Arise, integrity to make our nation proud. Arise, arise, defend the cause of freedom. Proceeding to the integrity to make our nation proud.
Thank you very much. Please kindly resume your seats. And then we will just take the photographs and we'll be out of here. So cameramen, please organize us. The first one will be the high table. We just stand in front and then we'll take the pictures.